Good morning, everyone, and welcome to the Senate Judiciary Committee. Today's date is March 28th. We're getting to the end of the month here, almost April, but I think we're getting some April showers a little early. We are going to start the day by opening the public hearing on House Bill 185 and recognize the prime sponsor. And let me make sure I get this name correct. Representative Post, please come forward. Make sure, Representative, that you introduce yourself for the record.
Good morning, and thank you for having me here today. My name is Lisa Post. I represent Lineborough, Mount Vernon, and New Boston. I'm here today to speak on HB 185.
Okay. No, please, you just speak.
Okay. So children love their parents equally, and parents love their children with all their heart and soul. Decades of research confirms that the time children spend with each parent after a separation or divorce, the outcomes for their families are better for the children and the parents. HB 185 works to ensure that children have equal access to both fit, willing, and able parents after separation or divorce, and that maximizes time with both parents. No matter what courtroom with 185, no matter what courtroom a litigant enters, it ensures that all judges in the Circuit Family Court Division begins with the presumption of 50-50 or equal shared parenting, all relative, because there is a lot of wiggle room for these families. They decide for themselves how they're going to do the sharing. The judge may deviate when the parents are making that plan. And if there is a clear reason why they shouldn't have 50-50, the judge has that discretion to change things. And that's abuse or neglect is a totally different issue. The parents that are doing this are, if there's any abuse or neglect, it is up to the courts to address that. Our children are our future, and the actions we take today allow children to have a happy, healthy life with both loving parents, sharing in a normal day-to-day activity that brings stability to their children's future. It's proven by many states that have passed this type of legislation that HB 185 works to reduce stress on the child with equal parenting and reduces legal conflicts and lowers conflicts between both parents over a parenting schedule and time. It reduces hostility that may spill over to the children. This bill also allows the courts more time to attend to cases that present significant risks of child maltreatment. When two parents are equally engaged in the rearing and well-being of their children, neither parent is likely to feel overburdened, stressed out by the day-to-day care and responsibilities of their children. With the current state of child protections in New Hampshire, the current laws are not working or being enforced. As elected policymakers, the citizens of New Hampshire have entrusted us to protect the rights of all, which includes our children. It's our duty to ensure that we are constructing laws that is constitutionally compliant and that we have enforceability. For these reasons, I urge you to consider the children and vote ought to pass on HB 185, and that's with an amendment, and there will be several people to speak on their amendment.
Thank you very much, Representative. Are there any questions from the committee? Senator Chandley.
Thank you very much, Madam Chair, and thank you for your testimony. You use the phrase equally engaged, and I think that makes a lot of sense, but that's really different from what this bill does, in the sense that being equally engaged does not necessarily mean that you have approximately equal parenting time. So I guess I'm thinking about certain circumstances. How would one accommodate, for example, a breastfeeding mother who would need probably, in order for the child to be appropriately cared for, would need more than 50% of the time? And the other circumstance I think about is, would this require two parents to live in the same school district?
Not necessarily on the school district. And the parents get to work out their schedule on their own. And this is so that they can work it out what's comfortable for both. So equal or 50-50 doesn't mean that specifically if one parent travels outside or is in the military, they will work out the schedule. This gives them the ability to have a schedule that they can modify to work to meet their needs of both parties. So as you were talking about a mother who was breastfeeding, they may have, for a portion of time when that child is really attached to the mother, right, because of the needs of the child, they can make those determinations on how they are going to share that child. And I think that's the best thing. And if you look at the literature that came out from other states that have done this, these families do much better. And in some of your literature that you have, it shows that for families that have done this for a period of time, the stress levels go down, the children are happier, and it's more of a, I'm going to say, normal family, because they get to interact not only with both parents, but if there's grandparents and cousins and things like that, they get to make those, to be a part of their larger family and have that structure that brings stability to the kids. Because all of us probably know that we grow up not just with parents, but with cousins, aunts, uncles, grandparents, and that's a big part of a child's life too. So I think that even though we are calling it 50-50 or equal shared parenting, there is leeway for those parents to make their schedule.
Thank you.
Are there any further? Senator Gannon?
Just help me along, because I did a lot of divorce work like 30 years ago, for a couple of years. And these were the goals that we were after then: equal parenting time, having everything 50-50. We knew the best interest of the child, even back in the Stone Age. Isn't this really what they're doing already? And you're just, no, it isn't. Okay. So in my head, I was already doing this 30 years ago. We're trying to.
It's really 10% of the population that really have difficulty creating a schedule on their own, and the back and forth bickering and the issues that go on. It has been proven in the literature, and I think there's about 4 states that have done it for quite a while now, that it shows that this allows the family to be more stable, happier, and the burden is not just on one person or the other. So for me, I would want my family, if I had a split, to share all the unit of the family together. And
I'll do my reading. Thank you.
yeah, thank you.
Are there any further questions? Seeing none, thank you very much.
Thank you very much.
The chair will call Representative Lori Ball.
Thank you very much for allowing me to speak. I'm sorry if I seem a little nervous or I'm moving quickly. I have a bill that is coming third on the docket upstairs, and I need to be up there. And I just got notice that they're starting the bills.
Well, Representative, before you get started, if you have written testimony, you can make sure to give it to Mr. Schulze We'll get copies. We're not execing anything today. We'll have plenty of time to read it because I know today is difficult for reps. So
I
if you
very
just want
much-
to paraphrase it really
Yes,
quickly.
I can
and then you
easily, I can easily do
scoop.
that, but I do want to apologize because I wrote education, because education bill, I'm like, that's been on my mind all week. Anyways, basically, this goes down to RSA 461 that says, because children do best when both parents have a stable, meaningful relationship or involvement in their lives, the policy of the state is to frequent and continued contact between children and both parents. This amendment that I put through only changes 4 words. Instead of saying frequent, continued, and continued contact, it says approximately equal parenting time. The reason this came up is out of the special committee on, when we investigated kind of the family court, we went out and we interviewed the judges, and we found that of all the judges in New Hampshire, only 3 of them did not start at 50-50. 3 of them start at 0 and then try and work up. This is a problem because it means that we are not giving equal justice or equal, justice to parents. It all depends upon which courtroom they get into. It's basically a crapshoot, and it's not fair. We were actually told that all we needed to do was change those 4 words, and the courts would all come in line, and that would be extremely helpful to all the parents. The rest you can read, but really it came down to when we did that investigation, finding those 3 judges that were doing their thing instead of what all the other judges showed us that we have inequity, and that's unfairness to all the parents involved. So thank you very much. I will give you, do you have any quick questions? I'm
Thank
so
you.
sorry. This is such an important bill, and we've had so many people come and testify on it. And just, frequent and continued contact, that doesn't mean FaceTiming. It's not fair to either the parent, whether it's the mother or father who's ever getting less amount of time. It's not fair to them to think that they're now going to be a visitor in their child's lives. And most parents, even after divorce, will change their schedules to make sure they are there for their children. The parents love their children equally, and we need to acknowledge that by providing approximately equal parenting time to both parents so that they have those relationships.
Thank you, Representative. Are there any questions from the committee?
Thank you
Seeing
so-
none, thank you.
Thank you so much.
The chair will call Representative Gibbons. Good morning, Representative. I will tell you because I know that
Yep.
the House is in session and you folks want to go. So
Yes.
if you have written testimony.
I don't. So
Okay.
just to play on what Representative Ball just said, I personally have experience with this, where I am going through a very contentious divorce. It's still an open case. And I can tell you that when we modified our custody agreement to equal shared parenting time, there was less conflict between me and my soon-to-be ex. There was more defined parameters where when you word it as frequent and continuing contact, that can be manipulated by people, and it's vague and it's problematic. One person could define frequent and continuing as daily, another person could define it as weekly, and the court could see it either way. So by saying that it's equal shared parenting and approximately equal parenting time, that's much more defined in terms, and that gives more structure and less room for manipulation by parties that are prone to do that to the other person. So I just want to encourage you, please, this is a really important bill. Those of us that are testifying here, we've spent a long time crafting it. It ended up being very simple language, but we feel like it's the best interest of the child. Thank you.
Thank you very much, Representative. Okay, the chair will call Janet, it looks like Delmon? Oh,
Sharon Carson, how are you?
good. How are you, Janet?
Honey, I'm doing well, thank you.
Good.
I came
Good.
specifically today because, well, me and Miss Carson, we go way back.
Yep.
She was actually going through this with me when I went through this years ago. At the end of the day, I'm pretty much here just to tell you all the final outcome. If you don't mind, I'd like to give a quick brief down.
Could you just make sure to introduce yourself
Oh,
for
I'm
the
sorry.
record?
My name's Janet Del Fugo.
Okay.
So I went through this in 2012. It started in 2005. I got divorced. Everything was amicable, 50-50. I had custody of my kids. My ex-husband moved to Bow, New Hampshire to live with his girlfriend. Everything was going good. She kicked him out. He had no place to live.
Yep.
To answer your question, I gave him a loan off of my house, not realizing the loan I was giving him to buy a mobile home in a trailer park 3 blocks from me. So I tried to do the 50-50. I tried. At the end of the day, my ex-husband took advantage of that, and this is why I am so for shared parenting. It takes the power away from the abuse. Remember that. It takes the power away from the abuse, okay? And what I want to play for you is what ended up happening to me. So I ended up in family court. I had my kids for 5 years. I was raising them. I have a house on 7 acres. I was in college for nursing. I was in college for my orthopedic degree. And all of a sudden, I was facing 3 different courts. I was everywhere testifying, and I was having a mental breakdown. I will own this, but you need to hear this.
You can't act the adult and be mature with him because you put him smack dab in the middle and say, you know something, Spencer, because of what you're doing, I'm not going to double, triple, quadruple my efforts to make this happen.
Manipulative, like he's being manipulative and he's learning it from him.
And you are being manipulated.
I'm not being manipulative. I gave this psycho a loan off of my house so he could live 3 blocks from me. What ex-wife, if you would have dealt with it, done that? And because of it, I'm losing my house that I got 15 years ago. And my son since I was 19 or married to that, he got the exact same house that my grandmother died in. They said, for 1,000 years, and they're dying. Don't sit there and tell me that I'm being a toxic woman because I'm not even trying to keep my family together. There's no one before I got a nervous breakdown. And by the way, even though my daughter original building, he still won't make, and you still won't find me to get that for. I'm done. I'm showing the abuse. I never even want to admit
Tells me that you
I'm done with the abuse. That went on for 3 more minutes with me screaming and crying in family court saying, I am done. I'm okay, honey. I've got this. I've got this. She's seen me have breakdowns one right after another. I was a mess. I tried to keep my family together, okay? My ex-husband took pure and just evilness of the whole entire no 50-50 in a courtroom and tried to take my children away from me. He succeeded with my oldest. He got my oldest full custody and I had a restraining order against me. He did not get my youngest. My youngest stayed with me because my youngest fought harder than me, okay? My youngest kept me together. No child should have kept me together. How dare somebody put an 11-year-old to make his mother stand up for me? But he did it. For 5 years after that, my ex-husband did everything in his power to keep us all apart. I was arrested a couple of times for talking to my child. Even when my child tried to talk to me, he was told to not have no contact with me. You're not allowed to see me. It was a mess. It got so bad, I ended up facing 4 felonies and 1 misdemeanor. My prosecuting attorney is sitting right there. Judge Weaver, who you just heard, took the bench and lied on the stand saying he never called me a bad parent. Well, hello, this was a weekly event for me, ex parte after ex parte after ex parte of my ex-husband trying to get custody of both my kids. It was never about me or what a mother I was. It was about the money. He wanted the child support. He wanted his house paid off. He wanted me homeless. He wanted it all. If 50-50 parenting was there in place, the abuse never would have happened. It would have happened because the power would have been taken away. It would have been taken away from the judge. It would have been taken away from my ex-husband. It would have been dissolved. I went back to school after my trial. Oh, I was found not guilty, by the way, because I proved that I was being abused. And I even took the stand, and at the very end, you can watch the trial, it's online. It was live streamed. Every lawyer, I think, in the state watched it. Everyone hates me. Everyone's afraid of me. I even said on the stand, I was the original victim. Why wasn't anyone protecting me? Nobody protected me. No one cared. There was no law to protect me. There was no law to protect my children. There was nothing. I went home. I took a year to regroup, regather. My oldest went into the military. He's in the United States National Guard. He's a Black Hawk mechanic. It took us a while to recoup because Daddy-O realized there was no more money in the game for nobody. So he ended up remarrying, moving to Florida. He has no contact with neither one of my children now. Took me a long time to get that narcissistic, abusive behavior out of my oldest's head. My youngest, Miss Carson, you'll be very proud to hear this because you remember Sam when he was a little boy, that little Cub Scout.
Yep.
He testified in front of Miss Carson about this abuse back then. My youngest grew up. He joined the United States Navy full-time. He is a Seahawk mechanic, and you should all be very proud. He is the youngest one in the whole country to make E5 with all of his qualifications at the age of 21. This is us three this past Christmas. For the first time we've all been together in 5 years because my children are serving their country. Country that tried to destroy them, a judicial system that tried to destroy them. It didn't work. I went on to get my paralegal. I have my associates as a paralegal. I don't do law because lawyers hate me. I graduated top of my class, but I stayed in the medical field. And once in a while, if somebody needs my help, I'll just shoot them to either the right attorney or the right way to find what they need. Judge was wrong. People were wrong. 50-50 needs to be present. I don't care what any advocate says about it can't be the abuse, this, that. For 5 years, me and my ex-husband did 50-50, and he lived in Bow and I lived in Northwood, and it worked. And we all got along until he found out that he could use the law to get those children away from me. At least he tried. Not all stories are success stories like mine, ladies and gentlemen. I know of people that have lost their kids to overdoses because they just got so messed up in the head. I was part of a very large group between 2012 and 2018. Not every story is as good as mine, but some are. This is on you guys now at this point to change the way.
Thank you very much, Janet. Are there any questions from the committee? Seeing none, thank you.
Thank you, Ms. Carson.
Could you call Representative Bickford, Janet? Can I talk to you? Sure.
Oh, thank you. Okay. Again, my name is David Bickford from New Durham, and I am very much in favor of the bill. What it is, it's a recognition of the U.S. Supreme Court decision of Troxel versus Troxel, came out of the state of Washington, which said the grandparents, in this case, do not have a right to the children. And it went on to say who does, which is the mom and the dad. So what we're looking for here is to be able to show that in the statute so people don't forget it. But the most important thing is to use this as a starting point in the statute. You say, okay, you walk in the court and you're 50-50 parents. However, when you walk out, it may be totally different based on what the court decides. And that's okay, if that's necessary. But it's really just a starting point with Troxel. I don't think people realize that's what we're trying to accomplish here. Now, that's all I need to say, I guess. Thank you.
to meet you upstairs. Monday. See you again. Introduce yourself.
Good to see you, Senator. My name's Deborah DeSimone. I represent Rockingham 14, Atkinson. I did not write my name down to testify on this, but I'll be very, very brief. I worked with Representative Post to create the amendment. I've been a representative serving the majority of my time on children and family law for 8 terms. This is necessary. This is important. It will alleviate a lot of animosity in the best interest of the children. This is one way to say to angry parents, take your children's health and well-being into consideration instead of your own anger. Thank you very, very much for your time. I will be hanging out because the next 2 bills I have to testify on too. Hopefully they'll be fast and I can get upstairs. Any questions? Thank you kindly for hearing me.
Good morning, Senator Gannon and members of the committee. My name is Pamela Keilig, and I'm the Public Policy Specialist at the New Hampshire Coalition Against Domestic and Sexual Violence. As you know, the coalition is the umbrella organization for 12 community-based crisis centers that provide free and confidential services to nearly 14,000 survivors of sexual and domestic violence annually. Thank you so much for the opportunity to speak this morning. I'm here actually in strong opposition to HB 185, which would establish a presumption of shared parenting. The coalition has worked with other child advocates over the past 25 years to fight similar policy proposals like this one because we know that it's going to put kids and protective parents in danger. RSA 461A, the Parental Rights and Responsibilities statute, was designed to ensure that parenting schedules would be tailored to the specific needs of a child and what would work best for the families based on their unique cases. The majority of parents in New Hampshire can agree, as you've heard already this morning, on how to parent their children. In these cases, equal parenting time may be appropriate, but in the less than 10% of cases where parents can't agree, and often the reason why is because there has been abuse or someone is in fear for their safety. These are 10% of cases that judges need to be reviewing very closely to help towards a resolution. These are 10% of cases where domestic violence victims and protective parents are trying to ensure that their children are not re-victimized or that there is no threat of further harm. Creating this policy is just going to force the people who are least likely to have a successful outcome into a 50-50 custody agreement. We cannot create a law that would grant offending parents access to the people they have harmed. RSA 461A was carefully revised only a few years ago with the support of over 20 child protection professionals and community stakeholders, including the coalition. If passed, this bill would be a huge deviation from current practice. Currently, the courts have clear guidance on how parenting should be determined in New Hampshire, with a specific intent to balance the understanding that children do best when both parents have a stable and meaningful involvement, while also ensuring that the identified outcome would not be detrimental to the child. And I think that's the really important part to emphasize here this morning, that the outcome is not detrimental to the child, based on the factors of the case, such as domestic violence or abuse or neglect. Under current law, judges have a responsibility to balance the rights of the parents with the obligation to ensure that the outcome would be in the best interest of the child. We should expect judges to take time and dig in to understand what is going on in these high conflict cases and what is best for the children. So-called high conflict and contentious cases often involve a parent who is scared for their own safety based on the abusive or violent behavior of the other parent. Asking victim parents to have high frequency contact in situations like this is not in the best interest of the child and actually could have long-term and extremely negative effects on their health and safety. Witnessing chronic parental conflict and exposure to domestic violence can have long-term physical and mental health implications, often referred to adverse childhood experiences, or ACEs. Upholding an abusive environment is not in the best interest of a child. If you pass this policy proposal, you are absolutely going to be placing a child abuse and domestic violence victims in situations where the abuser will have access and custody of them 50% of the time. It's unacceptable to tell people that they need to get along for the sake of their kids. It's unacceptable to tell a victim of domestic violence and a victim of child abuse that they need to maintain high contact with an abusive person. Do not tell the population that they need to get along and do a better job when they are in fear of their safety. What needs to happen is the offending parent needs to get treatment and get their act together before they see their kids. We need to prioritize accountability for those who have caused abuse and protect victims and children. We shouldn't presume anything about a family. There is no one-size-fits-all approach to parenting, especially in the 10% of cases I've been talking about this morning. The committee has passed important child protection legislation this session, and we're really grateful for your ongoing support. And this bill would undermine some of the work that you've already done. We strongly urge the committee to please vote ITL on HB 185. Thank you so much, and I'm happy to take questions.
Thank you very much for your testimony. Are there any questions from the committee? Senator Gannon.
I do. Senator Whitley probably already knows the best answers here, which I don't. I'm confused by everyone's for the best interest of the child. We determined that 35 years ago. So if the 90% of the time, right, we're going to split custody 50-50. So if this were to go through, isn't the judge just going to look at the unfit parent and say, we're not going to give them the 50% custody? Aren't they going to just make findings that support an order that says 70-30 or 20% best?
This creates a blanket presumption of 50-50 parenting, and there are no exceptions. And so our concern here is that we need to be looking at the specifics of each family case and weighing the different experiences and unique circumstances, and not putting a blanket presumption.
So I'm reading this wrong, and you can get me there. If the court concludes that approximately equal parenting time is not in the best interests of the child, they can come up with their own findings and support the order. So they could have a
Right.
90-10. So why is this going to fail?
So
I'm not there yet.
no, thank you
I
so much for your
apologize.
questions, and I'd be happy to follow up with some additional
Maybe I'll
information.
follow up, 'cause-
Yeah, we can.
okay.
I'd be happy to.
You
Thank you,
can
so
walk
much.
me through again.
Yeah,
Thank you.
I appreciate it.
Hey, are there any further questions? Seeing none, thank you very much. The chair will call Representative DeSimone.
I spoke.
You already spoke, okay, just want to make sure. Okay, next we are going to go to Beth Corey.
Do you do much for them?
Good morning. Are the both of you going to be speaking? Okay, just make sure you identify yourselves for the record.
Good morning, members of the committee. My name is Beth Corey. I live in the Upper Valley, and I'm here to speak against HB 185. As a survivor of domestic violence and a mother, this bill is terrifying. Standardized approaches are not appropriate where domestic violence is a factor, because that factor changes everything. The best interest of a child cannot be met if we ignore that reality in favor of a mandate of equal parenting time, and the dangerousness of a situation should not be overridden by a statute. This bill will put judges in a more difficult position, because even the best intentioned judges are guided and restricted by what the legislature puts in its enacting statutes. And conversely, this bill will put batterers in an easier position to gain access to their children, even absent that being in the children's best interest. And it will also make it easier for them to gain access to their victims, who will be forced to have greater contact with their abusers by virtue of having more pickups, more drop-offs, more communication. That is re-traumatizing, and that has a negative impact. Giving abusers more opportunities to be abusive in front of their children has a negative impact, and creating a fear of harm in the one safe parent that a child may have is creating harm. And although there is a clearly detrimental carve-out in this bill, it is not well-defined. And even if the legislature unequivocally stated in the statute that abuse by one parent against another parent is clearly detrimental to the child, I fear for those whose abuse is clearly borne out by the facts of their case, but who may not have the robust documentation to demonstrate it. The only way we can adequately protect children and abuse victims is to not limit judges' autonomy to weigh the facts of a particular case. We should not be forcing judges' hands to send children to spend more time with an unsafe adult. And I can't state more emphatically that any parent that abuses their co-parent is indeed unsafe. That is what the research says. That is my lived experience. And that is what we see play out on the news every time more children are orphaned because one parent murders the only other parent that their child has. New Hampshire should be creating laws that make it harder for abusers to get access to their children and their victims, not easier. And I will leave you with this for whatever it's worth. This is the first time I have ever publicly identified myself as a domestic abuse survivor, but this bill is so harmful that I am willing to put myself out here and identify myself as such in a room full of strangers in the hopes that you will not pass it. Thank you for your time.
Thank you very much for your testimony, Ms. Corey. Are there any questions from the committee? Seeing none, thank you very much for your testimony. The chair will call, is it Marilyn Mahoney? Did I get that right? Mahoney?
Yeah, my handwriting was not that great. Okay. But you got it. I do have. I have testimony. Oh, here it is. Good morning.
Good morning.
My name is Marilyn Mahoney. I'm a retired attorney who had my practice in Manchester for about 40 years, practicing in the area of family law. I never gave up. But in the course of that, I represented both mothers and fathers. I also worked as a guardian ad litem for a long time and come here with no personal agenda other than what my lifelong or career-long concern has been, and that is to always remain focused in family law matters on what is in the best interests of children. My concern, and I urge the committee to vote against 185, House Bill 185. My concern is that it changes the focus away from what is in the best interest of children. The language is still there, but those, as somebody pointed out, those 4 little words make a huge difference in the focus that the judges and that parents have to give when they're thinking about coming up with a schedule with 2 households. The 4 little words that we're concerned with replace the current language, which is to support frequent and continuing contact between each child and both parents. That's the current law, to support frequent and continuing contact. It's not a mathematical certainty. It shouldn't be a mathematical certainty because these orders that are, or agreements that are made have to last sometimes for 18 years. This is a long time. And as we all know, during those 18 years, kids grow, they change, their needs change. One sibling does something different from another. So we want those kids to have frequent and continuing contact with their parents. But given the circumstances, that might not mean equal. And it might not rise to the level of showing abuse or neglect or even detriment. It's the practical realities of everyday life that we have to focus on. Senator Chandley, I think you earlier mentioned the obvious example of an infant who is breastfeeding. 50-50 is just not going to work. And yet, with this language, there's no exception to that. This is supposed to be 50-50. Another example that I think we have to keep in mind are those children who have special needs, who may not have the adaptability that healthy and, I don't want to use the word normal, but a non-disabled child would have. So you have a disabled child who may need to have a certain accommodation that both parents may not be able to provide, either in terms of time or in terms of physical facilities. And we have to think about those kids too. This applies to them. There's no exception. Parents who live any distance apart from each other, you can't do 50-50. If dad lives in Nashua and mom lives in Keene, it's not going to work. And there has to be, should there be frequent and continuing contact? Of course. Should it be 50-50? It can't be. But that doesn't rise to the level of abuse or neglect or detrimental circumstances. The current language accommodates that. Changing this language is not going to change the horrors of domestic violence. It's not going to fix that. We have tools, hopefully, that are accessible to parents to address those issues. And I think you've heard from Ms. Kylie about the domestic violence concerns, but they are certainly legitimate concerns. We also have issues with the problem that arises as kids get older, and you have teenagers who have activities and who have a number of things going on in their lives that need to be prioritized over perhaps one or the other parent's time with the child. Frequent and continuing contact, absolutely. But can it be, as a presumption, always 50-50? It's just not practical. It's also not focusing on what we have always focused, well, at least for 50 years I can speak to, we've focused on what is in the best interest of the child. And this, I tell you, changes the focus away from that. It doesn't put the best interest of the child front and center. It puts a mathematical calculation front and center. And that, as a matter of policy, is not what we want to do. I have a longer written testimony that I don't want to just read to you, so I'll leave you to hopefully read that. But we need to be able, parents need to be able to modify or come up with parenting plans that isn't focused on meeting their needs. It has to be on focusing on what is in the child's needs. I've had cases already where people did seek a 50-50 certain schedule. And when that, if you have somebody, a parent who is a policeman or a fireman, their schedule is like 2 days of work and then 3 days off. And how do they try to do a 50-50 schedule? Well, I had a parent who proposed, well, I'll just have a babysitter during my time, rather than have the other parent having the children when they're available, because I have to have that 50-50 certainty. It's not my time and her or his time. It's the child's time that we need to always keep people focused on. Thank you.
Thank you very much for your testimony. Are there any questions? Okay, Senator Chandley, then Senator Gannon, then Senator Adams.
Thank you very much, Madam Chair. And I have 3 questions. I'll try to ask them all at once. And
oh, great.
and I'll remind. So thank you very much, Ms. Mahoney. My appreciated your testimony on the practical reality. And I was thinking, both when I asked questions earlier and as you were testifying, 50-50 is not really given a time frame. So I'm thinking about, well, when the answer to the, as we said, the obvious example of breastfeeding mother was that they'll work it out. And I was thinking, well, is working it out saying the first 3 years are with the mother, the second 3 years are with the father? I don't think anyone intends that. But how do we work the 50-50 time frame out? And then my second question was prompted by Ms. Corey's testimony. And I don't know if you can speak to this, but I was interested in her suggestion that increase the 50-50 split increases interaction between the two parents that can be problematic. So those are the two questions I have, really.
I was waiting for the third.
I'll leave it at that.
Well, I will, I don't have the sources today, but I will disagree with testimony that was given earlier about there being all this research of how 50-50 works. In fact, there's a substantial body of research. I know some is from California, and I don't have sites with me today, but I could provide those, where there have been longitudinal, very long-term studies done of families where states have tried to implement a requirement of 50-50 parenting time. Kids have not done well. The research has indicated that the biggest issue for kids when they're not doing well is conflict between the parents. And when you have the kind of schedule that puts parents in constant, continuing contact, you actually increase the amount of conflict. We want to do exactly the opposite. And that is to encourage mediation, to encourage the discovery of a schedule that is unique to that family and that works for that family. New Hampshire families are not cookie cutters. Every family is different and unique, and their needs are different and unique. So empowering parents to do as much as they can to work this out themselves, step one. Step two is to allow the court to have as much flexibility to ensure frequent and continuing contact, but a schedule that is not mathematically driven. Does that answer your question?
Yeah.
Thank you. So, and thank you for taking my question. So often, if there's, assuming this became law, often when a parent, if they're abusive, whether it's to the child or to their former spouse or partner, wouldn't that be evidence in and of itself, though, to find it's not in the best interest of the child to have a 50-50 schedule?
I'm sorry, I didn't quite understand.
So if this became law,
Yeah.
and one of the parties involved is abusive to the other or to the child, I mean, I think, wouldn't that in and of itself be evidence of that it's not in the best
It
interest?
doesn't work? Sure, that would be evidence of that, and that requires then a return to try to solve a problem that probably could have been resolved or solved ideally initially.
And then,
So it encourages more litigation. That would be my concern.
and a follow-up. And the point I'm trying to make, I guess, would you agree that it kind of goes both ways? I mean, absent, if the law remains the same, I guess the parties can still advocate for 50-50 if it meets the right circumstances, I guess, for the court. So it's not like they can't have that. It kind of goes both ways.
Absolutely. It happens all the time now. I don't know that there's a lot of energy spent, at least not by attorneys and mediators, doing a mathematical calculation to get to 50-50. But it happens all the time. I don't have any data. I don't know that there's any data available, but probably the majority of parenting cases that are getting resolved now have a very equally shared parenting schedule. People understand it's good for kids in the right circumstances.
One last follow-up.
Follow-up?
And I know that the 50-50 schedule can be virtually anything that's 50-50, but most of the ones I've seen or heard of, it's was 1 week and 1 week, 1 week on, 1 week off, or 2-2-3 kind of
Works
switching.
for older kids, yeah.
In your experience, when you've seen 50-50 parenting schedules, what do they look like?
All over the map. So little kids, you're not going to do 1 week with dad, then 1 week with mom. They can't stand to be away from either parent that long. Older kids, yeah, they like that idea of a week here, a week there. Parents who live some distance apart, it might be with one parent during the school year and the other parent during vacations. It's so idiosyncratic based on each individual family's needs. So.
Last question?
So it seems that you don't really favor a one-size-fits-all approach to this.
That would be fair to say.
Thank you.
I'm just going to step in before Senator Gannon starts. I'm going to ask the members of the public, some of you are having conversations with each other while you're here. I'm going to ask you, please, if you're going to have conversations, please take them out in the hallway, because the acoustics of the room, we can hear you talking, and it's very distracting when we have witnesses testifying in front of us, and oftentimes it just affects how we hear them. So I'm just going to ask you, please, if you have these conversations, just take them out into the hallway. Thank you. Senator, you're all set? Okay. Are there any further questions for this witness?
Thank you very much.
Thank you very much. The chair is going to call Dana Albrecht. Good morning, Mr. Albrecht.
Good morning, Madam Chair and members of the committee. For the record, my name is Dana Albrecht. Thank you so much for giving me the opportunity to testify this morning. When faced with a difficult political question, Dietrich Bonhoeffer asked not how to extricate ourselves from the situation, but how the coming generation should continue to live. And I submit to you that the question before you today is how the coming generation should continue to live. And I submit to you today that the answer to that question is right here in this book, The 50-50 Solution, Emma Johnson. And I would urge all of you to have a look at that. Clearly, I can't read it to you here. You don't want me to. But I'll hit a couple highlights. Note that I said simple or difficult, which doesn't necessarily mean easy. When Alexander Solzhenitsyn was faced with simple political questions that were not easy, he exhorted us all to live not by lies and penned a famous essay to that effect. And to address specifically a couple concerns I heard earlier in chapter 5 of this, roughly around page 201, you'll see all the very latest and greatest research showing that in every jurisdiction where this has been tried, domestic violence rates go down by half. It's quantitative. You can look at it. It's specific. You can read the rest of the book to see how much better this is for children. I won't read it to you. You can do that for yourselves. And so some questions I would have for all of you. Again, to live not by lies. If we want to believe the monstrous lie that this research is wrong, would we ITL this bill? I wouldn't. If we want to believe the monstrous lie promulgated throughout history that there ought to be second-class citizens, and what the current statute says there are second-class citizens. Even Thomas Jefferson, who wrote All Men Who Are Created Equal, didn't quite live up to that. I'm asking all of you to live up to that today. That lie is repeated throughout history. When I look at the senators here, more than half of you as recently as 2018 might not be able to drive in Saudi Arabia because of the ancient historical lie there ought to be second-class citizens. Get rid of second-class citizens. If I want to believe the monstrous lie that taxpayer dollars should go to 501c3 organizations to then be spent on political lobbying, to promulgate a further monstrous lie that there are not all of the carve-outs necessary to address all of the concerns. Would I believe that lie, or would I pass this bill? If I want to believe the monstrous lie that this doesn't promote peace and families, would I vote against this, or would I vote for it? And if instead I want to believe that all of the research shows that this promotes peace, and if I want to promote love, joy, peace, patience, kindness, goodness, gentleness in families, would I vote yes on this bill? And to promulgate this spirit of peace in families, if I know that through this we can acquire the spirit of faith, acquire the spirit of peace, through which perhaps 1,000 children might be saved, would I vote yes on this bill? Thank you.
Thank you very much for your testimony, Mr. Albrecht. Are there any questions from the committee? Seeing none, thank you.
Thank you.
The chair will call Myra Ryan. Good morning.
Good morning, Senator Carson, members of the committee. Sorry. My name is Maura Ryan, and I'm here to testify in opposition to this bill. I think one of the issues here is that co-parenting is a huge myth because it doesn't work. Basically, 50-50 time has been used or weaponized as a tool to not pay child support. I myself have a special needs child. I would not leave my child or split my child between a home because he cannot adapt to that. Children need consistency. That's the thing that they need most in their life. Certain professions, as mentioned before, have difficult work schedules where one parent is working over 100 hours a week and the other is working 40. That makes a big difference. That's not a consideration in this bill. I also have a client who I was advocating for in a divorce case, which is still going on now, where the judge ordered a 50-50 split and the husband was working overnight, so he left the child, who was a minor, at home alone and not at an age where that child should have been left home alone. 50-50 split focuses more on the parents than the child and their needs. And when a child is forced into visitation when they don't want to do so, that damages their relationship with that child. I have another client who I worked with who's when the child reached the age of 16, no longer wanted to do visitation with the other parent because of the forced visitation. In addition to that, I just want to point out that reporting abuse only works if someone is actually paying attention. There have been instances where people have reported abuse with clear evidence, including restraining orders, where judges still put an order of 50-50 in place, which was not in the best interest of the child. There are situations that can come up which can be dangerous for children, which would not necessarily qualify as abuse, but could involve the child being alone for long periods of time, or with strangers like babysitters or significant others who they've never met. And that creates a lot of anxiety for a child because they don't know this person. This is not their parent. And essentially, the way the court sees it is if the parent thinks that the person is okay, then that must be okay. But that's not how the child necessarily sees it. In addition to that, reporting abuse doesn't always change the outcome of the 50-50. And while Thomas Jefferson did write, "All men are created equal," he didn't include women in that statement who are adversely impacted by divorce in a bigger way, as are children. And, they're the ones who need some level of consideration. There are many women who have to go back to work, are not financially stable, become dependent on the state, and are left in a much worse situation than their partners when they divorce. And in this case, we have to worry about the child first and foremost, and all these things should be tailored to the needs of the child and not the parents, because the child is the one who's going to go out into the world who could potentially be another abuser if they observe abusive behavior. So that's my testimony. I'm happy to take any questions.
Thank you very much for your testimony, Ms. Ryan. Are there any questions from the committee? Okay, seeing none, thank you very much.
Thank you.
The chair will call Robert Tangway. Good morning, Mr. Tangway.
Morning, Senator Carson. Good to see you again. It's been a while.
It's been a little while.
You've helped me out before. What I'm passing out to all of you is criminal defamation at the State House by Governor Sununu. This right here is believed there's evidence that this was promulgated by the Domestic Violence Coalition. It says that I was ordered to have supervised visitation until I get a mental evaluation, and I refuse to do so, which is absolutely not true. And they know it, and Governor Sununu knows it too. On the other side is the letter of all the organizations I went to. I'm in support of this bill because it's constitutionally compliant. The way people are looking at the court system is completely wrong. It's not up to the state to decide what the best interest of the child. It's up to the parent. And a breaking up a family, which women do 70% of the time, initiate all divorces. And then you could also calculate how many times they get child support. Breaking up a family is abuse upon children. And if you look at the contractual law, if you decide to break up a business, which a family unit is the business of raising and rearing children, if you were to break up a family unit because you don't want to, except for abuse, obviously, because abuse is abuse, you would be causing a damage on the family unit. And we have candy buckets of child support, which is tax-free money, which gets awarded to women most of the time. And the women also get the children primarily. They're usually the person initiating the breakup, and they don't have any reason. And so when they bring up all these things about domestic violence, we're forgetting that the Judge Pauley case, the famous Judge Pauley case, the poor lady went to the police, was refused from the police. The Domestic Violence Coalition, she testified, by the way, it's on record. She went to the Domestic Violence Coalition, didn't show up to the final hearing. So with the protection order got dismissed, the civil protection order, which the police didn't do the job, and then someone went to her work, the person protected, and shot her in the face and killed himself in front of her. Very traumatizing, because the Domestic Violence Coalition didn't do what they said they were going to do. They also didn't take care of my issue. They invited me to their place, and they didn't. And then they called the police on me and did an alarm, and then tried to get the Concord police to interrupt me through the House of Representatives. And it's all on record. I have all these recordings. They're published. Governor Sununu knows about it. The Attorney General knows about it. The Special Committee knows about it. 50-50 is a good step towards this. I'm going to play a 1-minute clip of a domestic violence extension hearing. The judges don't follow the laws. Even if you give these laws and pass this, it's just a reminder to the judges on how they're supposed to perceive it. And it will actually prevent people from breaking up the family, which is supposed to be part of the grant money from Title IV-D It's action and law. I don't have that in front of me.
Mr. Tangway, before you play that, it's very, very difficult for us to actually hear that as you're playing it. Would you prefer to send it as a file?
No, I'd prefer to have it on the record, and I can make it.
Well, it'll be on the record if you send it to us. It's testimony. Okay.
You can hear it. I've done
that
that.
Heidi Ames is as an appearance according to the domestic violence court protocol, and she is not allowed to participate in this hearing anything more than an advocate. I do not object to offers of proof, but I will be calling to the stand. I do have an issue with, as I put in the pleading, the court has not given me the reasons for the extension.
That's the purpose of today's hearing.
Mr. Judge.
But you already granted the extension. This court did, Judge Chabot did.
That's the procedure under the statute and the protocols. And this hearing is to determine whether the extension will go forward. That's why we're here.
Respectfully, Your Honor.
Yes.
I object on the record to that. This law 173B extension states specifically that the court shall give reason or reasons. You've already granted the extension. The extension has been granted to offers of proof, but I do not object to offers of proof.
That judge was looking at a sworn affidavit by me stating the law, and then in writing, she still granted it. She granted a domestic violence protection order, no police contact, I haven't been arrested, was granted on physically and mathematically impossible findings of fact written by a judge, fraud. No. So when you have these people say that you're gonna break up a family, and as you have touched, Senator, as you have touched upon, but I feel like you ask only questions of the people who are advocates and actually paid lobbyists getting millions of dollars in grant money inappropriately. The police need to arrest on a crime. Breaking up a family is a crime. We're looking at it wrong. We're looking at it as if because you feel sad, one party feels sadder, they can do better, they can break the covenant of a family, which is the ultimate promise, the ultimate contract, even more than a marriage. And so you can't do that. You need to pass this bill because it accentuates 185. You also need to bring this defamation is from Governor Sununu's office by Jennifer Smith. And instead of taking any rectification, firing her, asking why she spread it and correcting it, they gave her a job on the insurance commission. They just moved her around. I'd be happy to take any questions. You guys need to pass this bill to remind people that the state should not get involved unless there's a conviction of domestic violence, which includes calling the police. Thank you so much. Do you have any questions, please?
Thank you very much for your testimony. Before I ask recognize Senator Abbas, would you send that audio to Mr. Scelzi so that he can get a verbatim transcript of what that said and include
Yes,
it in the
Senator
record?
Carson, I will. Thank you so much.
Thank you. Senator Abbas.
Thank you, Madam Chair, and thank you for taking my question. You played an audio recording, from my understanding, you may have been involved in a family law case. During those legal proceedings, were you represented by counsel at any point in time?
No, and the opposing counsel lied multiple times. They kind of bully you when they target self-represented pro se litigants, and they treat you like you don't know what you're talking about when you bring up the actual statutes.
Thank you.
Thank you.
Thank you.
I'm just want to ask you a question. Are you aware of the fact that we now allow paralegals to work with people that are representing themselves pro se in the court, in family court? So you would have had the opportunity to have one if you.
The idea is that the belief is that you can just call up 603 legal, but their website, one of the organization's websites doesn't even work, and they don't respond to calls. Everybody in the state, and I appreciate that. I'm very aware. I've read all the statutes, criminal statutes. I'm very aware and articulate. The issue is that we have this idea that we have this justice. Family law is very difficult, so I will give you guys that. Family law is very difficult to understand. They say, what do you want us to do? Cut a child in half? Well, what do you want to do? Cut a finger off a child? It's the most intrinsic part of our soul, our children. And instead of deadbeat dads, we have beat dead dads, it feels like, or women. When women get hurt, it's because they're not as politically connected as men. And I've talked to a lot of women who have had issues. There's bias, and we have to deal with that. But to answer your question, yes, I'm aware, but it's not, in actuality, it's not like that. What they need to do is increase, I looked at the application to become a lawyer, and they need to lower the standards to become a lawyer, and then have more disciplinary actions to bring the judges and the lawyers into compliance with the law. There's not enough lawyers, and it's kind of like a racket. They rent seek, especially off of family court cases. It's guaranteed money. People are spending hundreds of thousands of dollars and barely being able to see their children. And it's on record. It's in Supreme Court. You'll see. And the only way you really get any justice is if you pay a large law firm to write your Supreme Court brief, because they break the law and send it to appeal. These people aren't wizards of laws. It's written clearly. This bill 185 is written very clearly. You're innocent until presumed guilty. You're innocent and should be able to have your child. And what we should actually be looking at is the contentious parent, which is the parent who breaks up or makes false accusations. Unless there's physical or sexual abuse, there's no reason, no realistic way to break up a family without causing damage to the children. And then when there's physical or sexual abuse, you arrest the individual, reform them, and keep them away from the family, and they're the ones who cause the damage. They're the ones who lose out on the family.
Thank you very much for your testimony, Mr. Tangway.
And I appreciate you guys. I feel heard finally. Thank you.
Thank you. The chair will call Jennifer, is it Pike? Good morning, Ms. Pike.
Good morning. I'm here today to ask you to oppose HB 185.
Ms. Pike, before you start, could you please identify yourself for the record?
Oh, yes, I'm sorry. My name is Jennifer Pike, and I'm from New London. And again, I would like to ask you to oppose 185. I am a domestic violence survivor. I have been married twice. My first marriage was an abusive one. We had made plans. I was living in New Jersey with my first husband. We had made plans to move up to New Hampshire. And we had canceled the lease and everything. And then abuse started. And I had a 2-year-old daughter at the time. And I wasn't sure how to get out of the situation. I waited until he was going to be out of the house for a time. And I packed everything up I waited till he left, packed everything up and left. I left a note. He knew exactly where I was. But But by the time I got up here to my parents' house, because my parents lived up here, he had the police here on the other end accusing me of kidnapping and so forth. And I just want to talk to you a little bit about like how the abuser just takes every opportunity to re-victimize the victim, but not only the victim, but when you witness abuse, that is considered abuse. So my daughter witnessed abuse at 2 years old, and I would like to talk to you about the impact of that. I am the mother of 4 wonderful kids, 2 of which are my stepsons. But my daughter has long-term impacts from the abuse that she witnessed. And she was forced to continue visitation with him for a period of 3 years. She had to visit with him once a month. Well, it was supposed to be twice a month, but he didn't do his visitation. I had to drive her to New Jersey once a month. And it was supervised by his mother. She ended up getting a broken arm. The last visit, she was I ended up taking her to the doctor, and the doctor had questioned whether or not she had been sexually abused. She had never gone down again after that. And he terminated his rights after that. But she is now 30 years old and still has terrible impact. I mean, has terrible depression. Her relationships have been impacted by that for her entire life. Forcing a child to be in contact in that situation is not something that any judge or anything, I know that you talk about, that if it's not 50-50, that the judge can decide what they can do. But that's, the judges are very subjective in what they can do, and they tend to have a more positive idea of what what they can do. So I can tell you that in both my situations, they opted for a more positive, to have a more positive idea of what was going to happen. And it was damaging to my children. And I am left dealing with the outcome. I am left dealing with, having them in therapy and everything else, which is fine, but it's not fair to them. It impacts her relationships with her partner now. It impacts her relationship with her children. She has 4 children now. And on the other hand, with my stepsons, I mean, I've been on different roles. As far as the 50-50 goes, there is no way. I think the attorney that was up here earlier, hit it right, the nail right on the head. There is no way to have 50-50. You just cannot define that. Each individual family is just that. I mean, they are an individual family. They have their own individual needs. My stepsons, my older stepson, anything would roll off his back. He could care less where he was, what he, was doing. But my younger stepson, he was very impacted by his parents' divorce and really struggled for when he was young, going back and forth. So to have someone, define 50-50 and put a 3-year-old in that situation is just insane. Thankfully, his kindergarten teacher spun it for him that he was lucky that he had 4 people that loved him. But it took a long time. But then on the flip side of that, as they get older, again, they get involved with all their activities. And then they want to be with their friends. Now, we were between New London and Hanover, which is still a pretty far, 40 minutes, basically, haul back and forth. So I was in the car constantly, driving. That's all I did. To activities. I got them to every single thing, didn't matter where it was, what they did. We were in the car to their activities. Their friends were always at our house as well. But it was hard. It was exhausting, but it was in their best interest. Then you come to my youngest son. My youngest son has multiple complex disabilities. When I divorced his father, he had supervised visitation through the visitation center. He had visitation every Sunday that he did not want to participate in. I had to wrestle him to get him in the car. Physically wrestle him to get him in the car. Many times we were late. But I got him there because I was legally required to get him there. He was screaming and crying, and I took videos, but it didn't matter. I had to get him there. And when we got there, sometimes I was able to get him out, sometimes I was not. Sometimes the people in the visitation center made him get out, sometimes they didn't. And so but then my ex only participated in visitation a few times before he disappeared. So he left the country. In that case, that was godsend, because then he hasn't heard from him since then. So that was in 2013. So, as much as you want to, I understand that you want to make, a defining effort here. There's just no way. There are just, even in the best of circumstances, I understand that, these sound crazy to you, but I swear to you, I'm a normal person. This is not, I don't, it happens. It happens everywhere. So there's just no putting 50-50, that definition on a family, because families are just too individualized. But I'd be happy to take any questions.
Thank you very much for your testimony this morning. Are there any questions from the committee? Seeing none, thank you. Seeing that everyone who
Thank you.
has signed up to speak has spoken, we're going to go ahead. Ms. Gay, you're here, but you did not sign up to speak. Yes, I have the sheet here, Ms. Gay, and you, you signed in to support it, but you did not check to speak. Ms. Gay, you are more than welcome to send us written testimony. We're not executing this bill today, so all right, then come on down. You have a minute. I will just go ahead and mark you as speaking.
Thank you. Domestic violence.
Please introduce
Oh,
yourself.
excuse me, Betty Gay from Salem. Domestic violence is always my concern too, and that seems to be everyone's concern who has spoken against this bill. If a parent is an abuser, 10% breakup is not good either. If a judge is not sympathetic to domestic abuse, as that's covered by line 8, or a much worse outcome is what I have observed. An unsympathetic judge has repeatedly given 100% of parenting time to the abuser. So the issue is not 50-50. The issue is presenting abuse to be considered, or any of the other concerns like special needs. 50-50 is an excellent starting place, and 90-10 does not solve the problem. We need to have better ways of addressing domestic abuse in court, possibly just being in criminal court, but that's not for me to decide. This bill is excellent, an excellent way to start making the field level. So thank you.
Thank you, Ms. Gay. Are there any questions for Ms. Gay? Seeing none, thank you. Okay, I'm going to go ahead and close the public hearing on House Bill 185. Oh, I just closed the public hearing, sir. I announced that everyone who had signed up to speak had spoken. So the public hearing is closed. Sir, you are more than welcome to submit written testimony. We're not executing this bill today.
Well, there'll be other you didn't give me an opportunity, you spoke to this again, I appreciate that. There was not any other question offered before you spoke.
Well, sir, at the beginning, before I recognized Ms. Gay, I said that everybody who had signed up to speak had spoken, and you did not pop up.
You didn't give me it's fine.
I think, sir.
I appreciate the opportunity not to speak as your letter specifically to speak on this. I arrived, the list was already up there, so I didn't have a chance.
Okay, sir, the list is still back there. In fact, when I sat down, I had one. I now have 3 that we went through. So you could have signed up and come forward. Unfortunately, I gavelled it. It's closed, and I can't open it up without scheduling it on another day. So that's why I said, sir, if you have written testimony, please send it to us. We're not going to exec this today. We'll have plenty of opportunity. We do have a number of children and family law issues on our docket today. So if you'd like to stay and speak on a different bill and just reference this bill, we'll take the testimony. Okay. Here you go. Thank you. Okay. Let me know when you're ready, Matthew. You're all set? I'm going to go ahead and open the public hearing on House Bill 535 and recognize the prime sponsor, Representative Hole. Is Representative Hole here?
Madam Chair, I believe, obviously, the House is in session right now.
Yes, I know.
When we had the last witness, I did send a friendly text message just to
Would
let them know.
you like to introduce the bill, Senator Abbas?
I can do that as a
okay
courtesy, and I think some of them might come down.
Okay, he has every opportunity to testify. Go ahead.
Good morning, Senator Darrell Ebbs. I represent District 22. I'm here to introduce HB 535-FN. I'm neutral on it for now.
Thank you. Sir, would you like to come forward and testify? That's okay. We're going to take the testimony on the other bill. Sure. Just make sure to introduce yourself for the record.
Certainly. My name is Tim Penasack. I'm from Hollis, New Hampshire. And other than the 15 years I spent in the military, I have lived in New Hampshire, and recently I've been dealing with issues associated with allegations of domestic violence. My ex-wife has accused me of domestic violence. I lost my children for 2 weeks. There were no data, there was no allegations, there were no proof. It was thrown out. I am not going to talk to you about the data that says there's 7,000 families a year that file for divorce in here. I'm not going to talk to you about the fact that fathers shouldn't have to justify and rationalize and testify that they should have time with their parents. I'm not going to talk about that. The data's been thrown around. I'm going to give you an example of my case. I'm the CEO of a tech company based in Nashua. I have 4 wonderful children, and my children have been taken from me multiple times. In 2021, my ex-wife was arrested for failure to comply with the court order for parental interference. She then filed filed an ex parte motion alleging domestic abuse. This was after she was arrested, 2 days after. In that process, because of COVID and because of a continuance that was filed, it took me 6 months to get in front of the court to address that with my attorney. At that point in time, we were assigned to Marital Master Dalbra. Marital Master Dalbra ignored all the conditions associated to the filing or to the arrest and asked why the kids weren't spending time with me. We had a GAL. We paid for GAL, the kids are in therapy. And the GAL was heavily involved in our case. And when that case finally got in front of a different judge after Dalbra resigned, the case was brought forward, and it was the testimony from my children's therapist and the GAL was the only thing my youngest daughter, I have 4, 2 boys and 2 girls. The only thing my youngest daughter said, she was upset that when I got married again, I took my then wife for a 4-day visit to London and she wasn't able to go. So when you are thinking about 185, understand that it is a preponderance position. It starts at 50-50. Give the judge the ability to adjust as necessary. Because as many of those organizations can argue that there are allegations and there's reality regarding domestic violence, and I am not going to try to demean that because it happens and I understand that. But there are false allegations that occur that impact families. And impact children. Because my kids wanted to be with me and they couldn't because of false allegations. So I would ask that organization that testified, how many times do they actually vet the allegations? I understand the law. I understand what happens. The allegation is made, right? It is filed, and then the court takes a conservative approach. Understand that completely. But how many times do they actually vet that? Sorry, I'm jumping around a little bit, but the point being here is that fathers and the other parent should not have to testify in court to show that they're a good parent. What needs to happen is there needs to be an understanding, unless there is proof that a parent has an abusive nature or there's allegations of it, that it needs to be proven in court before you can say that a person is not good enough to be a parent and be with them. There's plenty of studies, and I'm not going to go through that. I'm not going to have that conversation because there's plenty of them that say that both kids need both parents in their lives. So I seem to be jumping around, and I had prepared a statement, and I didn't want, and I apologize for that. But I would ask you as you think about 185 specifically, right? It is not an argument. It is not a law that says it has to be 50-50. It's a law that states it should start there and be adjusted by the courts. Let's legislate for the majority and adjudicate for the minority. That's all we're asking for. It has to start somewhere. I appreciate the fact that you allowed me to speak.
Thank you very much for your testimony. What I'll do is I'll make sure that it'll be included here, but I'll also ask Mr. Schulze to include it along with the other testimony from 185.
Thank you.
Thank you. Are there any questions?
I have a quick question.
Senator
So
Gannon?
I totally feel for your case. I have 4 kids. I would not know what to do if I lost them. But my problem would be the evidentiary standard that where they talk about clear and convincing evidence. So if someone had an accusation, I always want to be on the side, even if it's erring on the safety of the children. So with this high evidentiary standard, you'd have to prove, like to almost a criminal degree, that you did this. Even so, we might be 60% you're guilty of doing something. That would be enough for me to want to protect the kid, not to have to go to this high evidentiary standard like a criminal trial. So I'm thinking I'm protecting your interests over the children then.
So, Senator, again, I appreciate the comment and the question, but it's based upon an allegation by one party against another. If I had never met you before and stepped in this thing and I said, well, you, sir, are an abuser, what is it based upon? It's based upon a hearsay component. And I recognize that in family court, that the rules of evidence are relaxed. And I recognize that the court needs to operate in what is the best interest for the children. But just because someone says it doesn't mean it's true. As stated, it was alleged twice. I had a police investigation on the first one, and the police testified. There is no fact behind that. There is no truth to that. And it was thrown out. The second time, after she was arrested, she filed that ex parte pro se motion, and the court just said, there is nothing to show. There is no medical records, there's no teacher records, there's no counselor records. There is nothing other than her stating it. So while, yes, it is a bit of a call, if you would, for our judges, that's what they're paid to do, right? They have to make that. So how do you say that? Are you arguing, Senator Gannon, that one should, sorry.
No, you asked the question I was going to answer. So I just am trying to understand, if it was 51% even, if they lowered the evidentiary burden from clear and convincing to a preponderance of the evidence, I would be more apt to be in favor of this bill. But the evidentiary standard is so high here that I would think you'd have a hard time ever overcoming that in a family court.
But what's the evidentiary standard?
Well,
that's what I'm saying. But if you have allegation, my point is if you have an allegation without any evidence, if it's one person's testimony versus another, how do you show that one person should lose parenting time with their children solely based on what I said or what she said? There is no evidentiary component associated to that. That is just total hearsay.
Okay, I'm all set. Thank you.
Are there any further questions? Thank you very much for your testimony. Okay, I saw Representative Hall walked in and he just walked out. Yeah, okay. Okay. Okay, we've got quite a few people who wants to speak on this. So we're going to start with Melissa Mascio. Ms. Masio, I see that you provided written testimony. I'm just going to ask if you can, don't read it, please paraphrase it. We are way behind in our schedule. We're not going to be executing any of these bills today, so we will have plenty of opportunity to read your written testimony.
Absolutely. Thank you, Chairman.
Thank you.
Carson. My name is Lissa Mascio. I am the Associate Child Advocate for the state of New Hampshire. I am also an attorney and have previously practiced both in private family law as well as DCYF, representing both parents and the state. So bringing that experience to my role here at the OCA. I know you all know how important HB 535 is because you just passed SB 463, Senator Carson's bill on Tuesday, which is substantially the same bill. This bill was retained by the House, and a lot of work was done over the summer with CASA, the Office of Child Advocate, and all of the community advocates that are part of the JRPG, many of whom are here today. As most of you already know, the OCA's piece of this was our experience in Bledsoe Youth Academy this past summer, where we found 2 New Hampshire youth who were placed there by the state under 169 C and B for therapeutic treatment in a trauma-informed way. And instead, what we found was 2 children in a juvenile detention center wearing prison-style garb, sleeping on the floor, and being abused and humiliated. So this bill is a very important step to prevent things like that happening, in addition to several other bills pending this session. This bill in particular would give children in residential placement, or preferably prior to being sent to residential placement, attorneys, legal counsel within their 169C case. This is in addition to the already very important role that CASA plays, representing the best interests, but the attorney role is different, representing that child's expressed interest. I will let other folks talk to that particular piece, but the Office of Child Advocate feels very strongly that getting attorneys for this particular group of children is very important. I was not done, but I could be. Nope, sorry, my mic cut out for some reason. I just wanted to. That might have been me. Oh, no problem. I just wanted to bring a couple important pieces of information that the Office of Child Advocate has. As some of you know, we present to the Oversight Commission on Children's Services every month. Part of what we present is data. This is as of the end of February from our last report. The data is that there are 124 children in a child protection case, so that's 169C specifically, in group homes. So out of the almost 1,200 children in care, both in child protection and juvenile justice, only 124 are in this category of children that would be automatically getting attorneys. In addition, I just want to point out, frankly, I'm a little bit confused by the ask by the division as far as needing 14 additional child protection workers. I can tell you that the work that was done on this language in the fall was crafted very specifically, and I'm looking at paragraph B, 2B on this, to align very directly with current policy and practice, to use the current triggers being done by current DCYF workers. So there's already workers who are these kids' caseworkers. So we crafted this language very much specifically to align with what's happening now. The trigger points that get a child into residential care is sending a referral for a CAT evaluation. As you know, that is what evaluates a child to determine level of placement, or sending out packets to placement, residential placements. You have to put information together, send them out to see who will accept that child. So there are already people obviously currently doing that. It would be those events that would trigger the notice to the court, which is also already currently required by law. So this is already happening now with workers that already work for DCYF. Those are the triggers in this bill that would get that child that attorney. So it is very unclear what 14 new workers would be necessary. So I just wanted to point out that that language was very carefully crafted to not require additional personnel, to really take into consideration what is already happening and what those trigger points would be, to streamline that process and not create any additional work for the division in that notification, in getting, obviously, they're not the ones getting the attorney, but that process is already happening. So I just wanted to point that out. You're welcome.
You know, the bills that we passed, if they're passed in the Senate, they'll be in finance. I have received, an update on costs.
Oh, okay.
So they're, I brought them over to Senator Gray, she will be putting them on the bills in finance. So, if you're concerned about the actual cost, you'll go to the finance hearing, if, I'm pretty sure they'll have them. And you'll know the updated cost.
Great. We love finance hearings. Thank you.
Oh, so, sorry. Okay. Next, we're going to call Emily Lawrence.
Able to bring up Karen Rosenberg and Lisa Wolford.
Sure, that'll be fine. Sure. Just make sure before each one of you speaks that you identify yourself for the record. If you have written testimony, please submit it. We're not execing today. And just paraphrase what you're going to be saying. Good morning.
Good morning. For the record, I'm Karen Rosenberg. I'm the Policy Director at the Disability Rights Center, and I'm here with
Lisa Wolford. I'm a lawyer and the Executive Director of the Children's Law Center of New Hampshire.
And I'm Emily Lawrence, the Deputy Advocacy Director with Waypoint.
Thank you so much for your time. We'll try to be brief because I know you're running really late. As you are well aware, this bill is strikingly similar to a bill that you've unanimously voted ought to pass, I think yesterday or the day before yesterday, and have put on the consent calendar, and that's SB 463, with the intent being to provide a limited right to counsel for children who are in the foster care system. And as you may also be aware, New Hampshire is an outlier. We are one of only 6 states that never, ever guarantee a right to counsel for children under any circumstances. And what this bill would do is establish a right to counsel for children, about 10% of the children who are currently in DCYF custody, as you heard from the Office of the Child Advocate, to have counsel. These are children who are in potentially dangerous residential placements, but they are in institutional placements or at high risk of going to institutional placements. So what I've distributed to you are some reasons that we think at the Juvenile Reform Policy Group that it's important that this policy pass. And then I've also distributed a packet of DCYF policies. These are the policies that I believe Lisa Mascio referenced when discussing that a lot of the trigger points, the notification requirements that would be imposed in this bill are already embedded in current DCYF policy. So what I've provided for the committee is a packet of those policies highlighted where those requirements occur. And I will hand it off to Lisa.
Good morning again, Lisa Wolford. I wanted to mention that the Children's Law Center is a legal services nonprofit, and we are dedicated exclusively to the legal rights of children, and we provide representation in child welfare proceedings, including in abuse and neglect proceedings under 169C. We do the work that HB 535 contemplates lawyers will do on behalf of children in abuse and neglect proceedings, and I'm here to testify in support of HB 535, as I did with regard to SB 463. So just a couple of points to supplement the written testimony that I've provided. The first is that the General Court has provided children with very explicit rights in 169C proceedings and under RSA 170G21, which is the Foster Care Children's Bill of Rights, and that children have due process rights to fair procedures before the state interferes with the integrity of their families, and to fair procedures before the state removes them to restrictive and sometimes harmful residential placement. What we found in the course of the work that we do representing kids in abuse and neglect proceedings is that judges and parties are not familiar with these rights and are not accustomed to these rights being brought up in the course of abuse and neglect cases. We've also discovered that the New Hampshire Supreme Court, because there are no annotations to your statutes with regard to the rights that you've already given, that the general court has already given to children, the New Hampshire Supreme Court has not been given the opportunity to assess the legal rights of children provided in these statutes. We presume because children do not have lawyers to appeal to the Supreme Court on their behalf with regard to those rights. I also wanted to note that there are court protocols that are promulgated for abuse and neglect proceedings, and that the most recent court protocols, which are about 300 pages long, were released in December of 2023, but they were drafted without the input of anybody identified as a legal representative for a child. And all this means to us that the rights of children in these proceedings are not being protected, and that they are often invisible in abuse and neglect proceedings, in which these kids are not just victims to parental abuse and neglect, but by law are also parties. This is not CASA's job, right? CASA volunteers their work is not to represent the legal rights of children. And we understand the important role that CASA plays in these cases. This bill is a modest bill that targets a small group of children, and it is good policy. As I outline in my letter, the data on outcomes for kids in placement is really awful. I wanted to say finally that the Children's Law Center and New Hampshire Legal Assistance have worked with the executive director of the Judicial Council to draft standards for the representation of children in these proceedings, and that the Children's Law Center is committed to providing training for lawyers who will do the work of representing these children. Thank you for your time.
Thank you all for your testimony this morning. Are there any questions? Senator Whitley.
Thank you, Madam Chair. Can you outline any substantial differences between the bill that we passed 2 days ago and this bill?
I would say there are not substantial differences. The bill you passed 2 days ago includes a statement of findings, which discusses what the circumstances are and why this policy is important to promote. It also restates some of the current law around CASA and the importance of CASA and what CASA's role is. It doesn't change that. The description of institutional congregate settings is slightly different between the two bills. The bill that you passed yesterday has a broader list of what we consider institutional congregate settings than this bill does. This bill refers only to, I think it's it refers to group homes, and I'm forgetting the citation. 170E25 is the site. So other than that, it's pretty much the same.
Are there any further questions from the committee? Seeing none, thank you all very much for your time this morning.
Thank you so much.
Thank you.
The chair will call Michelle Wangering. Okay. We will call Emma Savigny from New Futures.
Hello, thank you for hearing my testimony. My name is Emma Savini. I'm the Children's Behavioral Health Policy Coordinator at New Futures. I would also like to just doubly underscore what my wonderful colleagues have just described this bill and the importance of it. I would just like to highlight that the outcomes for children who are represented by counsel are better in many respects. Particularly, they are able to have shorter times between reunification with their parents where appropriate, or placement in a permanency, adoption, or guardianship. They also have fewer school transitions and shorter time to foster care. And so all of that combined means that there is more time for these kids in their communities where they can get access to community-based services, which is part of our system of care. And those community-based services offer better mental health outcomes for kids. And typically when you meet a child in their community and you provide community-based services, those children don't rise to the level of acuity that would require the higher level of care in hospital settings or residential placement settings. So not only is representation important at the court level, but the long-term effects are really important, and ensure that kids have better access to community-based services in our system. I'm happy to take any questions, but.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you. The chair will call Erin Cregan. Good morning, Ms. Cregan.
Good morning, Senators. Erin Cregan, I'm the General Counsel for the New Hampshire Judicial Branch. The Judicial Branch does not have a policy position on the bill, but I would like to raise for your consideration a practical implementation question, which we would appreciate legislative guidance on, which is that many of the judges who preside over these cases and work in this area are aware of a shortage of parents' attorneys who are available to take the mandatory appointments under 169C. And there is a little bit of concern that I know there are many who are very passionate about making sure that these attorneys will be available if there are mandatory appointments of attorneys for children, but at least a little concern that there may not be enough qualified attorneys to fulfill all mandatory appointments. If there is guidance that the legislature would like to give on what a judge facing a situation where there is not an attorney available should do, whether they should proceed or take some other action, that would be helpful to us, because although it is not generally possible when implementing legislation to foresee every possible eventuality and legislate for everything, this is at least one eventuality which to some judges appears it could very likely occur.
Okay, thank you very much for your testimony. Are there any questions for Ms. Cregan? Seeing none, thank you.
Thank you, ma'am.
Okay, we've finished the list of individuals who wished to speak.
John Williams.
Yeah, I know, I saw it. Please identify yourself for the record.
Good morning, Chairperson. My name is Susan Larrabee. I am DCYF General Counsel and Chief of Legal, Regulatory, and Legislative Affairs. I have nothing really more to add. I just want to echo what others have said, that it is such an important and essential part of the process for children to have a say in court. In a courtroom that typically is outside of their control due to no fault of their own. And that is why for years, DCYF has been part of the model court trainings that have gone on for children and youth in court, promoting that children and youth have a right to come to court post-adjudication to have their voices heard by all in an otherwise very overwhelming process. And that is why DCYF does not take a stand on the bill, but we do echo what others have said, that it is a very important part of the process to have them involved in this process. However, I know Attorney Macio was talking about the fiscal impact and questioning some of our asks in the bill. Obviously, we want to do this bill right, and we want to do it correctly in terms of fulfilling, giving every child a right to seek an attorney. And that is how Part 1 of the bill reads. And that's why there is a little bit of ambiguity in terms of, first, who is the one responsible for giving the child that information, and when are they giving that child the information? There's been a lot of conversation today about children in placement, particularly in residential placement. But Part 2A of the bill, on page 1, lines 3 through 13, discuss how any child involved in an RSA 169C case may request counsel. So therefore, that is why our appropriation in the companion bill was asking for more caseworkers, because as it reads, it would be the responsibility of the caseworker to go over that right to an attorney, because we are reading it in conjunction with the new paragraph on page 2, lines 3 through 8, that talk about the addition to the Foster Care Children's Bill of Rights, which states the department shall provide the child with a written statement of these rights and the process by which to request an attorney. And in speaking with our client counselor, the Department of Justice, as well as our own meeting on this bill, there's ambiguity in terms of who is providing that written statement to the child, and how is that being presented to the child, and when is that being presented to the child? Because according to 2A, it's any child may request an attorney. And the Foster Care Bill of Rights, which by federal and state law goes over their rights for children who are out of home in placement. So that Foster Care Bill of Rights, which has gone over with the child during the case planning section of the case by the family service worker, would contain what is in the bill, but that wouldn't be the first time that the child should be informed of their right to seek counsel, because 2A says that at any time they have a right to have an attorney appointed. So again, that's just why we are asking for maybe a little bit more clarity in terms of who is to be giving the child their written statement of rights and the process by which to request an attorney, because it's the department's position that DCYF should not be giving, legal advice to a child. And there's no parameters over what a child is. Who is a child? Any child under the age of 18. Under the federal guidelines, the Foster Care Bill of Rights is gone over with any child, has to be gone over with any child 14 and over. By practice, we do it with children 12 and over, because we are of, full belief that it's that motto of not about me without me. So we want to have children involved in the process in an age-appropriate way, but the bill is ambiguous. There's ambiguity about who the child is, what age the child is going to be receiving this information, and who are they receiving this information from. With the Children and Youth in Court Protocols, Chapter 8, Part B of the Model Court Protocols relative to abuse and neglect cases for promoting children attending post-adjudication hearings, there is a form letter that Judge Susan Ashley, sends out to all children and youth, inviting them to court, explaining the process to them. It is the GAL or the CASA GAL that gives the child that letter and goes over with them in an age-appropriate way their rights to be heard in court. So that may be something that would be the appropriate place to have their rights of legal representation made known to them. And CASA and private GALs are trained on giving this letter to the child, and they also have a court video that they show the child in companion to that letter. The video is entitled "To Court I Go." And again, that is something that the court produced to explain the process to them.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you. Okay, seeing the last person who had signed up to speak has spoken, we're going to go ahead and close the public hearing on House Bill 535. This is great. No, I got my drink. I got my drink. Does anybody want some water down here? Shannon, do you want some water? Yep. Okay, this one, we only have 3 people. Okay, are we all set? Matthew, are you all set? We're going to open the public hearing on House Bill 618, and recognize prime sponsor, Representative Spillane.
Thank you, Madam Chair, members of the committee. I hope you will find 618 as easy as I consider it. It was new to me to find out that we were automatically garnishing all wages from everybody in child support situations, just as default, even if they weren't in arrears or anything, and there was no reason to, even if the parties got along well, et cetera. When I looked at the RSAs for it, I found out that basically things were changed, and that's the way they automatically do it. But there is the right for two parties to make an agreement and not have wages garnished, and it's not being told to people. So I put this bill forward to have the courts notify people of their right to make an agreement, and that they will be able to be notified at their final hearing. They can also the family court has to develop a standard form that will detail the details of the when the garnishment of wages would become mandatory, so that they know that if they miss payments and things, now it will be garnished. Allows both the parties to determine their preferred payment arrangement, inform the payer that the record keeping is their responsibility, and how they should report missing payments. Just a standard form that can be given during the court's process of doing all the paperwork that they normally do in a divorce situation. And so this is basically just in the situation where both parties agree that they don't want to go through garnishment, they'd rather handle it on their own, that they're notified that they have a right to do that, and they're given a form to fill out with the court that binds them to that agreement. And that's essentially the way that this bill goes. It is my understanding that there will be certain circumstances in which this will not be allowed. I spelled those out. The committee amended this, and I believe they took out the specific requirements for some reason, but I basically said this should not be applicable to any time that there's already a protective order in place, obviously. Should not be applicable if one of the residents lives out of state because it's too hard to collect a missed payment in that situation, and should not be allowed if somebody already owes back child support to somebody else. And those would be the only three qualifications that would prohibit them from making an agreement with their partner that they want to not be garnished, but do it on their own. And I can tell you this was something I wish I had known when I was going through my divorce, because my ex and I get along great. And she came and asked me at one point if I could pay early a couple of months so she could register my son for summer camp. And I said, that'd be great. Let me call Bureau of Child Support Services and find out how they credit me for that. And they said, we don't know how to handle an overpayment. If you send us money in addition to your garnishment, we're going to send it back to you. So there was no way for me to get her money and have it credited towards my child support. I just had to cough up some money and hope she was able to give it back to me at some point so that she could register him for summer camp. But, you know, in his best interest, it was getting him in summer camp. This would make it easier. People could pay a couple of months in advance here and there if they need to. Heck, they could pay for a whole year in advance if they wanted to. And so I think it's just a matter of notifying people that they have a right already in our RSA to make that arrangement, and that's all this does.
Thank you very much for your testimony, Representative. Senator Chandley has a question.
Thank you. So would I be correct in understanding that you are suggesting that this is an opt-in rather than an opt-out?
Correct. The two parties, if they so determine during the divorce, can opt in to having their own plan. If none of that is done, they go automatically to the same standard way we cover it now, which is the garnishment. But it informs them that they have that option, that right available, gives them a copy of the form they can both fill out to discuss the terms of how the payment would be made and at what time during the month that payment might be made, et cetera, and also gives them a disclaimer warning of what happens if they fall behind.
Thank you. Are there any further questions? Seeing none, thank you very much, Representative.
Thank you.
I have Representative Deb DeSimone, but she's... Okay. Okay. Seeing that the last person who signed up to speak has spoken, we are going to go ahead and close the public hearing on House Bill 618. Representative, I'm going to try to get you out of here as quickly as possible. So I know you are upstairs and in the voting mode. Just if you can, Representative, let her know that she can just bring the testimony to Mr. Shelzy upstairs on the 3rd floor, and he'll put it in the bill file. Oh, jeez. Shelzy, Mr. Shelzy. Yes, for 618. We're going to open the public hearing on bill number 1111 and recognize prime sponsor, Representative Spillane.
Thank you again, Madam Chair, members of the committee. I appreciate you being flexible for us being in the voting mode upstairs and things. I'll try to be short. This bill is the same as you saw last year, and it was interim studied. We have passed it again through the House. We have made one change to it. That one change is that during the debate in our own committee in the House side, we realized that there's no strong penalty in place for professional mandatory reporters who fail to report. And we felt it was only fair that if we're going to put a penalty in place for someone who knowingly, with intent to harm, makes a false accusation, that we also hold those professional reporters, i.e. doctors and counselors and such, who have always been mandatory reporters in this state, even before we passed the law that opened it up to be everybody a mandatory reporter, that they face a penalty if they fail to report above what they would get from their licensing and such, which is the way it's apparently handled right now. So the committee added that as an amendment in the committee because they felt that strongly in a bipartisan way that needed to be addressed as well. So this essentially does not change any of the ability to report anonymously. It just encourages people to leave their name and number so that DCYF can follow up with them if they need to on any reported case. It gives the department the flexibility to also give a warning to the person calling if they know this is someone who has called multiple times, that making a false report could be something that leads to a penalty. And the bar is extremely high for that penalty because the DCYF would have to be able to refer this to the Department of Justice for follow-up with the ability to have evidence that the person has repeatedly made false reports in order to hit that bar of knowingly false with intent to harm. It's not going to hit your first-time reporter. It's not going to do any of that. I believe I sent a great detailed email to every one of you, including some references and the fact that 29 other states, including New York and California and Massachusetts, do have penalties of some sort for false reports. We're one of the outliers that don't. And I will leave off with saying that the governor supports this, and he has made it clear he's ready to sign this. It was not something that came about lightly. I did use the input from Director Ribson when he was director of DCYF to craft this bill. And the way that it's passed the House twice now, I think sends a message that the people want to see something done.
Thank you very much for your testimony, Representative. Are there any questions? Seeing none, thank you very much.
Thank you for your time.
Okay. Moving forward, because we are so out of our block of time, I'm going to make a request that you try to limit your testimony to 3 minutes. If you have written testimony, please do not repeat that testimony. And if you have written testimony, please don't read it. Try to paraphrase it as best you can. We are way behind, and we want to make sure that everybody who's here who wants to be heard has an opportunity to be heard. With that being said, I'm going to call Rep. DeSimone, who just walked into the room.
Thank you for your indulgence, Madam Chair. For the record, I'm Representative Deborah DeSimone. I represent Rockingham 14, Atkinson. I'm not going to take up a lot of your time because I think we all, over the years, have understood the issues around false reporting when it comes to abuse and neglect that a parent is supposedly committing on a child. Many, many years ago, as a young parent, I thought it was appalling and abusive to use four-letter words in front of your children. I called and I reported a parent for doing that and was told, much to my dismay, that that's really not abuse. Morally, I disagree with that, but I get where they were going with it. I was never in fear that I was falsely reporting and something would happen to me. Some of the opponents to this bill will say that it will keep good people from reporting bad things. I totally disagree. I believe that since we are all mandated reporters, the majority of the people who would take the time to pick up the phone and make a legitimate phone call about abuse are not going to be deterred from any bill that or law that's going to say if you do it out of disrespect or anger and it's not true, it's not going to deter the legitimate calls. It's only going to deter, and if it doesn't deter, it will give teeth to the state to do something about those phone calls where a knock comes on the door during dinner and the children are made to go into another room, disrobe, show the police their bedrooms, show the police the basement of your house because there were claims of abuse and neglect and supposedly a child was being held in the basement in a cage and it never happened. The child is traumatized, the family is traumatized just because somebody's angry with that family or one or the other person in that family. I think this is a very important bill, and one of the things that we need to do in the legislature now is to look at the fact that there's no repercussion to going in and upsetting an entire family like that. There are no repercussions for that. I think we need to have them, and I thank you for your time.
Thank you very much for your testimony, Representative. Are there any questions from the committee? Seeing none, thank you.
Thank you.
Okay, the chair will call Susan Larrabee. Ms. Larrabee, if you have written testimony, please make sure Mr. Schulze has it. When you're ready, let me know.
Thank you, Madam Chair, members of the Judiciary Committee. Again, thank you for having me, Susan Larrabee, DCYF General Counsel. Again, by way of procedural history, in reviewing this bill, it appears nearly identical to Bill 1612 that was put into interim study in 2022. In regards to this bill, House Bill 1111, which was before the Children and Family Committee on 1/9/24, where Director Fleischer provided information to the committee but remained neutral on the bill itself. So again, remaining neutral on the bill itself, the department is concerned over the chilling effect it may have on the see something, say something reporters that are so vital to reports coming into central intake. It is also possibly having a chilling effect with the campaign that is currently going on with the Granite State Children's Alliance, what is called the Know and Tell campaign. And interestingly enough, in reviewing that campaign online, it states that, as we all know, we are all mandatory reporters in the state of New Hampshire. However, It is reported that only 2/3 of adults know that they are mandatory reporters. And that coupled with the fact that RSA 169C39 already exists, and that states anyone who knowingly violates any provision of the Child Protection Act shall be guilty of a misdemeanor. We are concerned that, again, this would lead to many already apprehensive callers to either hang up the phone or not give any more information, because what is mandated in this bill is that according to page 1, line 10 through 14, it is the department, so it would be the central intake worker who is receiving that call. It says the department shall inform the complainant that should the complaint be made maliciously or with intent to harm, the complaint may be subject to criminal or civil penalties. It is unclear as to why the department would have to give that caveat to a caller who is calling in when they do not have to give the caveat, which is contained in the other section of mandatory reporters, that there is civil immunity and criminal immunity for those who are calling in, making a report to this chapter. Anyone participating in good faith. They don't read that into the caller's ear when the caller is making a call of concern. And again, during this call to intake, the intake worker is trying to gather as much information from the caller as possible. If there is this warning of possible criminal or civil liability, they may hang up and/or never report something that they have seen that caused them concern again. Instead, the worker is there to focus on what the caller heard, what the caller saw, what led them to call into central intake, and of course, getting as much personal information from them as possible. That yes, they are allowed to report anonymously, but the central intake worker tries to get that information of who they are and what their contact information is, because if this case is screened in which it meets the definition of either abuse or neglect on its face, it is then the assessment worker who is going to do a rigorous and comprehensive assessment, and that includes calling and meeting and interviewing that mandatory reporter.
Ms. Larrabee, you've got over the 3-minute mark. Please, if you have written testimony, make sure to submit it to Mr. Shelsey. Again, we're not execing this today. We're going to be holding these for a while, so we have every opportunity to review any testimony that you have and to ask questions.
Thank you. And I will be in the audience if there are any questions throughout the hearing, because I know in the prior hearing, there was some misinformation about DCYF workers being able to take a child from the home without a court order. And of course, that is not accurate. Okay. Thank you. Thank you all.
Okay, the chair is going to call Lisa Mascio. Let me know when you're ready, Ms. Mascio. And please, if you have written testimony, please don't read it, just try to paraphrase it for us.
Thank you. My name is Lisa Mascio. I am the Associate Child Advocate for the state of New Hampshire and also an attorney who has worked in this field both as a parent attorney and as a DCYF prosecutor. As you all know, the Office of Child Advocate's purpose is to protect the best interests of children, particularly by overseeing child-serving agencies, including DCYF. We agree with the department in this case that this bill as written would have a chilling effect or could potentially have a chilling effect. In particular, to be noted, Director Fleischer's testimony in the House, while it was informational only, he did indicate that the department does not feel this bill is necessary and that false reports are not an issue for them particularly. So this did not come from the department. I think the couple of things we'd like to point out is it would affect reporters' willingness or ability to come forward, but I also think this would have a disproportionate effect on the division. I'm actually pretty surprised there isn't a fiscal note or a request for additional positions, because this would put an enormous amount of work onto central intake and the assessment workers, because their job is to go out and to assess the safety of a child. And it's not just based on what that reporter reported. Once you get a report and it screens in, you go out and assess everything. They might have called, like Representative DeSimone, about a parent swearing at their child in a parking lot. But once they get to the house, it's their job to assess the safety and welfare of that child. It is not their job to assess whether the initial report was false or to somehow assess the intent of the caller. Never mind going even further, and somebody, presumably the assessment worker, is supposed to also assess whether there was a professional mandatory reporter who should have acted and didn't. I don't even know how you would find that person. But this would put an enormous burden on those assessment workers or those central intake folks to be not doing their job of protecting children and assessing that child's environment, but in fact assessing the intent of whoever called. And to be honest, the intent in this bill, as a criminal attorney would know, it's extremely high. Maliciousness or intent to harm is a very high standard. And I can tell you, even from my prior family law practice, well, there are reports that are made that might not be true in the end, that might not rise to the level of abuse and neglect. People calling are perceiving a danger to that child, and they should be encouraged to call if they perceive it in a danger, not said, well, if we think you did it because you're in a nasty divorce, now you're going to be penalized civilly and potentially criminally. These folks are acting in that child's best interest when they call, and we would not want this chilling effect. This did come across on a very close vote. I do recognize there are prior bills that have either been killed or interim studied, and the OCA is against any move to chill the effect of reporters.
Thank you very much, Ms. Masio. Are there any questions? Senator Abbas.
Thank you, Madam Chair. I understand the concern about maybe you think that people will be afraid to make reports, but we already have it for like police reports. It's a crime to make a false report to law enforcement. So wouldn't that, I mean, I don't think that really deters anyone from contacting the police. So why do you believe that would have a deterrent effect in this case?
I believe that the intent of prosecuting does have a chilling effect. People might be afraid to make a report to police, but that's not our concern. Our concern here is 169C and the state's decision to make everybody a mandatory reporter is to encourage everybody to call if they have any suspicion, if anything raises a red flag, even if it's your own moral center saying kids shouldn't be sweared at in a parking lot. The intent of 169C and that mandatory reporter law, as we have had for ages, is to encourage more reporting. So in this context, penalizing and who determines if it's false, who determines if it's malicious or with intent to harm, would have a chilling effect that would endanger children. I mean, that's really the difference. A false report to a police officer could be on any topic. This is specifically to protect our most vulnerable children. We'd rather get more reports and be able to protect them than have any sort of inference that if you call and you're wrong, if you call and maybe there was a history with your neighbor and you don't get along, but you really legitimately think that child is in danger, we don't want any chilling effect on protection of children.
Thank you.
Okay, are there any further questions? Seeing none, thank you. The chair will call Emily Lawrence. Let me know when you're all set, Ms. Lawrence.
Good morning, Madam Chair and members of the committee. My name is Emily Lawrence, and I'm the Deputy Advocacy Director with Waypoint. I do have written testimony, so I'm going to be very brief today. I agree with the others that have testified about the concerns for this bill having a chilling effect on reporters. I also would just like to say that we have some concerns that the bill could be weaponized in domestic violence situations. There is already an imbalance of power in those situations, and if an abuser threatens that if someone calls in to report what could be a well-intentioned report of abuse or neglect in the home, that you could be subject to civil or criminal penalties, that again could have a chilling effect on reports and reduce those reports, which in those cases, we certainly want to hear those calls coming in. The only other point that I wanted to make was, and Attorney Massio did refer to this, but about the language regarding those who in their professional capacity as a mandatory reporter. This language is on page 1, line 23, as well as page 2, lines 9 to 12. That language is a bit unclear because, as you know, everyone in New Hampshire is a mandatory reporter. So if you're referring to professional reporter, it's not apparent who that would be unless you're intending to refer to the list of professions that is in the mandated reporting statute. And in that case, it seems as though there's going to be a higher standard for those reporters than there currently is now. So I just think there could be some more clarity on that point if the bill were to go forward. But we would prefer that the bill not go forward for the concerns that I've argued already. I'm happy to take any questions.
Thank you very much for your testimony. Are there any questions? Seeing none, thank you. Ms.
Thank you.
Lawrence. Okay, the chair will call Myra Ryan. Let me know when you're all set, Ms. Ryan.
My name is Maura Ryan, and I'm here to support HB 111. I'm an educational advocate for special needs children, and I have seen the mandatory reporting weaponized against parents who attempt to advocate for their children to get better placements in schools. In particular, I had a mom in Wyndham who was advocating for her child, who called me the next day after an IEP meeting where she said, I want a different educational placement, and she was informed that a DCYF complaint had been filed against her. The complaint was educational neglect. All she wanted was a different placement for her child. She had a home visit where they went through her whole entire house. And to me, that doesn't seem like a necessary factor. Why does somebody need to go through your whole entire house just because you want a different educational placement for your child? The parent described to me the humiliation of having someone from DCYF go through her house. I also am a member of the State Advisory Committee, in which the Parent Information Center reported that they do not necessarily mandatory report against other parties who are abusing children. The only mandatory reporting they do is against parents. In particular, they don't report teachers. So they stated that if a parent calls and says, I believe that a teacher is abusing my child, they are referred to another line to call. And I would like to remind this committee that Howie Leung, a teacher who engaged in sexual misconduct with students, was reported by a student. The student was punished. The school knew about the report because they punished the student. However, the superintendent was never punished for not reporting that student's complaint, and Howie Leung was never charged for sexual misconduct in this state. Subsequent to that, 2 additional teachers in the Concord School District were arrested for sexual misconduct with no subsequent reports to DCYF on those teachers. In addition to which, the State Advisory Committee heard testimony that these complaints against teachers and potential abuse do not go anywhere. DCYF does not investigate them. So I don't understand whether this organization is reporting against any adult that's abusive or specifically just parents, in which case you're setting up a situation where parents could be potentially targeted if they don't agree with a point of view. I would also like to point out that symptoms of abuse also coincide with symptoms of poverty, and being poor is not a crime. That's pretty much it. I'm happy to take any questions.
Thank you very much for your testimony. Are there any questions from the committee? I just wanted to ask you, you talked about a case you had in Wyndham. Did the parent report that to the school board, that all she wanted to do was to just get a different educational plan? Did she inform them that this is something that happened to her?
She was very upset about the situation. She did inform that, and as a result, she was looking at homeschooling her children and pulling them from the school entirely, because that's a traumatic experience.
Okay, thank you very much.
She's not alone in that case, and there are other people who are going to speak further on that, but in the interest of time, I wanted to sort of sum up.
Thank you. Okay, the chair will call Jennifer Pike. Adam, could you make sure to pull the chair up for Ms. Pike so she can sit down?
Good morning again.
Good morning, Ms. Pike.
My name is Jennifer Pike, and I am from New London. I am here to ask you to support HB 1111. I too am a special education advocate. And like I said earlier, I am a mom to special needs child. School districts are using this act of making false abuse and neglect reports against parents with special needs children that have IEPs as retaliatory measures for advocating for their needs against parents regularly. It's a common practice. This has happened to myself 3 times within the schools. The first time it happened to me was when I showed up to an IEP meeting in 5th grade. It was not announced to me. Typically speaking, you get a meeting notice with all the attendees. He was not on the notice. I showed up to the meeting and there was a strange man at the meeting. And I had no idea throughout the entire meeting who this person was until afterwards. I found out it was someone from DCYF. And he was then told that he was coming back to my house afterwards to inspect my home. And I was being accused of educational neglect, which was ironic because I was accusing the school of educational neglect. And it happened 2 more times after that through the school, one of which was, oh my gosh, just recently. My son had gotten on the bus and he quickly got off the bus and said, oh, wait a minute, I forgot my water bottle. Oh, my mom's going to kill me. And he went to get his water bottle and the social worker heard him, thought nothing of it, but the special ed director was close by and told her to report it. All of these things have come back unfounded. But I also have been reported by a medical professional as well, because they were trying to discharge my son because he was going to be turning 19. And they wanted him discharged before 19, actually. They wanted him discharged at 18 from the clinic, from the autism clinic, and insisted that he be discharged. However, they were in charge of all his medications and had been monitoring his medications since he was 3 years old. And by law, they are required to continue to monitor his medications until I can find a psychiatrist or another provider to monitor his medication. And that is what I was trying to communicate to this doctor. And I have had all the documentation. She kept trying to refer me to a place in Concord that I could not go to because we were going to be losing other providers. I kept communicating that to her, and she refused to listen. And she also reported me to DCYF for medical neglect. Again, that came back unfounded. So again, these are, very traumatic events, not necessarily for me. I mean, it was maybe the first time and the second time, but for my child. Because when someone comes in your home like that, he he has anxiety to begin with, along with all of his other diagnoses, his 40 plus diagnoses. So when someone like that comes into our home, the trauma is just, incredible. He thinks that he is going to be taken away from me. So this is not fair. This is abusive. This is not a domestic violence situation, but these are people from the school. Not only that, but this is also using these resources in ways that keep people from looking for Harmony Montgomery, for example. So I'm done now.
We can, thank you.
Do you
I
have any
gave
questions?
you the rest of Ms. Ryan's time because she didn't take the full 3 minutes.
Okay.
So I wanted to make sure that you had that extra time.
So that's all.
Thank you very much for your testimony. Are there
Any questions?
Are there any questions? Seeing none, thank you very much, Ms. Pike.
Yeah, thank you.
The chair will call Kate Shea.
Good morning, Madam Chair and Committee.
Good morning.
Thank you for hearing my testimony this morning. I'll keep it quick because I know lunch is upon us and everyone's probably hungry. I did send you my testimony in writing. It was very long. And I just want to say a few things here today. If you put yourself in the shoes of someone in a movie, we've all seen a movie where there's terrible injustice, right? Whether it's The Color Purple or The Green Mile, you have this feeling of rage and just such sadness inside for that character, right? And feeling the injustice that they're feeling. I'm going to be emotional today. I'm warning you because I have a scarlet letter that's emblazoned in my soul because of the mistreatment to my family. I'm the daughter of a public school teacher who turned social worker. I'm on the Special Ed Advisory Board. I also help advocate for families with kids with special needs in this state. And I have an army that's invisible that's behind me today. They're not here because they're all working and a lot of us are marginalized. When you hear about the 50-50, this comes back to that too. And it comes back to the cycle of poverty and all those things. Our system is set up, and this is not about DCYF by any means. This is about the abuse and using a system to weaponize it against other people. This brings back to me those emotions because it brings back just like a neighbor of mine who got a note in her door this past week saying, your yard is a mess. You should be ashamed of yourself. I'm going to be making a call because I see kids in your yard. And I reached out and I found out she not only had that accusation, she had many more that had been falsely made against her for various things, including losing a foster child they were going to adopt. It was a 4-year-old in a nasty daycare, got, nasty over things and decided to call in a false complaint and had that child immediately taken out of their care, further traumatizing a child that already was traumatized. So this is not about the process or problems with that. That's being worked separately, right? This is about abuse and injustice. And 6 years ago, my family went to hell and back. I mean, we went into family court. It took 6 long years, tons of money. And basically, a winner was picked and a loser was picked. And I happened to be the loser. And so it didn't matter, none of that mattered. But it was about the abuser seeing what he could do with the system. And please pardon this humble drawing because my children used all the printer paper. And I didn't have time. So you got a perpetrator. That's the person, that's the mastermind behind, forgive my shaky hands because this is very emotional. This is the mastermind behind all of this. So in my case, a jury of my peers wasn't involved. About 12 or 20 people were involved, colluding with him on each one of these counts. Approximately 7, and if you split them out, maybe even more, all unfounded. Again, this is not about the process we have today. It's about somebody finding a loophole and finding a way to abuse, and also finding a way to twist even a guardian ad litem in favor of, and the court system in favor of, he the winner. And it's not a man-woman thing. This is just somebody that finds a way to manipulate the system and to use it to their advantage. So in all of these cases, and you have the testimony, I gave you a lot of details. When you have a sick child especially, this is adding insult to injury. So I also have a couple kids on the spectrum. One of them has a permanent brain illness that is complex. We also find ourselves in crosshairs like this a lot. We're used to it. We're very thick-skinned.
but I'm at the end of the thick skin, and I am tired of seeing people in my community harmed, and then others like Harmony going missing and not having resources to be used in the appropriate way. I do process reengineering. I'm in IT as a day job, and I do this other stuff on the side to advocate for people. But these incidents are not just harmful to the alleged chilling effect of whomever is supposedly being hurt. They're harming me. They're harming people like me, and it's permanent. Your blood pressure, your health, everything. And every time another one's logged, that's another 7 years. Your police know, the schools know, everybody in this picture knows, and you're stuck in the middle of it. So I would ask you to please support this bill. We've got to do something, and we got to stop the witch hunts. And in the words of the man from the Green Mile, I'm tired. So that my soul's been taken, it's God's, but it's been taken by people on this earth tramping all over it. I live for my children now, and I live for the people I can help advocate for. But we got to stop this abuse. Thank you.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you very much. The chair will call Betty Gay. Ms. Gay, when you're ready, 3 minutes.
Thank you. Betty Gay from Salem. And the reason I speak is luckily I'm not a victim, but you will notice that the people who support this bill have been victims who are parents. They are not the ones who are concerned about somebody making a false call. They're not worried about calling and reporting and being found negligent or nasty. They're concerned about other people calling them. And you notice that the people who don't like this bill are not victims. It's theoretical for them. DCYF has testified. I've been to many, many hearings about family court and children and I can't even talk right now. Children and family law is my main concern. I'm concerned about everything, but that's really where my heart is. So I've listened to a lot of testimony. DCYF has sent people who say that a huge percentage of the calls are unfounded. So they're wasting a tremendous lot of their limited resources to investigate these calls. They said as high as 90% are unfounded. That may be a little high, but anything that wastes their time is really, really important. Note, I want to tell a story, if I can tell it really quickly, about one family that I know. Somebody was mad at the dad, and they knew the mom smoked. So they called DCYF and said their special needs child had cigarette burns on them. So for some reason, the local police came to investigate this. They decided to come at midnight when they were sure everybody would be there. So at midnight, they knock on the door. They demand to see the child. They wake this special needs child up in the middle of the night, bring him downstairs, undress him, verify that he has no cigarette burns on him. The child was terrified for months, scared to death just to go to bed. It was totally unfounded. It was totally malicious. But nothing happened to the people who made that accusation. So it's time that we put some teeth into doing something that is irreparably harmful. I've had the experience, I've had two of my close friends have actually called because they saw children in very bad circumstances and called into DCYF to make a report. They didn't even get called back. One of them never got called back. The other one was called back and said, oh, it's unfounded. Well, they know what they saw. So I'm thinking that DCYF's limited resources, it's really important to protect those and put some teeth into the people who do this maliciously.
Thank you very much for your testimony, Ms. Gay. Are there any questions? Okay, seeing none, thank you.
Thank you.
The chair will call the final speaker, Mr. Albrecht. Good morning again. Well, nope, we still got 5 minutes. Good morning.
Good morning again.
Let me know 3 minutes, and when you're ready.
Yeah, Dana Albrecht. Very briefly, to echo my earlier comments on HB 185, but to this bill, I would reiterate the strong need, well, to pass HB 185 to eliminate that there are any class of second-class citizens in this state who are getting a bum deal. I would reiterate from that testimony the need to live not by lies. Now, moving forward to this bill, you just heard from, I believe it's Ms. Kate Chu, who is a victim of, appears to be a victim of weaponization of the system. And we have a whole class of citizens in this state. Hopefully it's not too large, but let's get rid of it altogether, that are victims of weaponizations of systems. And the way you accomplish that, again, live not by lies. These are serious matters. The more in matters like this, truth is promulgated, and the more in matters like this that lies are rejected, the better outcomes you're going to have across all of these cases. To briefly echo, I heard from a different bill, Senator Gannon, on sort of evidentiary standards and that sort of thing, to address that in light of this. The language says, knowingly files false report with malice or the intent to harm. If somebody doesn't, if somebody does that, should there not be serious repercussions? There's two very relevant state Supreme Court cases you could look to. State v. Kristen Ruggiero at 163 NH 129, 2011. State v. Brendan Bisbee, 165 NH 61, 2013. If you're getting into the weeds of evidentiary standards, false reports of abuse, sort of all of that, those are some good guidance for you. But in closing, I would just say, if I want to make sure that people who abuse the system deliberately and maliciously suffer consequences, would I vote yes on this? If I want to ensure that truth is promulgated and lies are rejected, would I vote yes on this? And if I want to ensure that we don't have any second-class citizens that are victims of weaponization of the system, would I vote yes on this? Thank you.
Thank you very much for your testimony, Mr. Albrecht. Are there any questions? Seeing none, thank you.
Thank you.
I'm going to go ahead and close the public hearing on House Bill 1111. Yep. Are you going to get up for Representative Me? Okay. Yeah, because I got an email from him that he is not available. So we're good. Okay. Set. We're going to go ahead and open the public hearing on House Bill 1220. We have received communication that the prime sponsor was not available today. So our own Senator Chanley has graciously offered to speak for the representative. Good morning, Senator.
Good morning, and thank you, Madam Chair. On behalf of Representative Ming, I would like to introduce House Bill 1220FN. It is an act relative to abolishing the collection of racial and ancestral data for use in the marital application worksheet. And I suppose that's it. And I believe that as amended, it includes abolishing the collection of educational background as well.
Thank you very much, Senator. Okay, Chair will call Sean Locke.
Chair Carson, members of the Senate Judiciary Committee, my name is Sean Locke. I'm a Senior Assistant Attorney General and I direct the Civil Rights Unit at the Attorney General's Office. I'm here on behalf of the Attorney General to testify in support of House Bill 1220, which is a bill that we had requested. I'll start with a little background for where this bill came from. So in February of 2020, Governor Sununu and then Attorney General McDonald received notice from advocates that RSA 5C41 required people seeking a marriage license to provide information about their race and ancestry, and that such requirements in states across the country are a vestige of laws designed to prohibit interracial marriages. Now, and therefore could be constitutionally suspect. In New Hampshire never had prohibited interracial marriages, but this was introduced, or this language came into being in the mid-19th century. The governor's legal counsel, then Attorney General Formella, and I consulted. We agreed that the best course of action would be to remove the requirement in New Hampshire. However, and on March 9th, 2020, Governor Sununu asked Speaker Shurtleff and President Soucy to use then House Bill 1644 as a vehicle to enact this change. Fortunately, shortly after that letter was sent, the COVID-19 pandemic began and the legislative session, kind of all those efforts fell by the wayside. In April of last year, we were contacted by those same advocates about these changes, what had happened with them, and realizing that they had been lost in the COVID chaos, we offered to propose a fix for this issue, which is House Bill 2020. The history of this language, the history of the race and ancestry requirement came in 1858. It first appeared as the marriage process shifted from a process where basically to publish that you were getting married and members of the community come and object to that, to the application process that we kind of see today. And that at that time, when it was first adopted, race and ancestry requirements that had to be introduced, had to be presented to get your marriage license and to be married. There's no legislative history from that time that remains that would explain why that language necessarily added, but it's certainly, at that time, the political climate, both in New Hampshire and across the country, raises kind of the specter of this was done to discourage or prevent not just interracial marriages, but marriages between people of different ancestral backgrounds. There was a lot of anti-Catholic, xenophobic views at that time. So in preparing this legislation, I consulted with also Vital Records and the Department of Health and Human Services to learn if this data had any modern use. And this data has never been used other than to present statistical data around marriage applications since the mid-1990s. So this data, essentially all it does is become a statistical data point. It's not used in any way. It's not given to any agency. There's no objection from, and I believe Vital Records testified at the previous hearing in the House, there's no objection to removing these requirements from this statute. And importantly too, these records are kept in a worksheet that you fill out to apply for a marriage license. After the marriage license has been issued and executed, those worksheets are destroyed. So this can't be used for genealogical purposes. There's nothing that this data can then be used for. But for the legal issues that arose here, the challenge is when these requirements have been challenged in other states, they implicate the Equal Protection Clause of the state and federal constitutions and the fundamental right to marry, which warranted strict scrutiny to be applied and required the statute to be narrowly tailored and to serve a compelling state interest. Now, where this data isn't used in any way by the state, it certainly, would certainly create a significant challenge to show that there's compelling state interest in collecting and gathering this data. There isn't the same history in New Hampshire of kind of trying to protect racial integrity necessarily, but absent kind of a clear legislative link to the state's interest, it could present significant legal challenges to the state. And so we propose this as a way to avoid those legal challenges in the future. And I'm happy to take any questions.
Thank you very much for your testimony this afternoon. Are there any questions? Seeing none, thank you very much.
Thank you.
Okay, I'm going to go ahead and close House Bill 1220, seeing everyone who signed up to speak has spoken. And the committee will be in recess until 1 o'clock. Thank you all for hanging in there. let me do this. The Judiciary Committee will come out of recess, seeing that it is just a few minutes after 1. We're going to open the afternoon, and we're going to open the public hearing on Senate Bill 1006 and recognize the prime sponsors, Representative Kitab. Good afternoon, Representative.
Good afternoon. Thank you, Madam Chairman and honorable members of the Senate Judiciary Committee. For the record, my name is Representative Caitlin Kutab, and I'm here to introduce House Bill 1006, which is relative to creating a family access motion for the enforcement of parenting plans. Currently, right now by statute under RSA 461A:4-A, if there's a motion for contempt, the court has to review it within 30 days, but they don't have to take any action. And sometimes they don't take any action for 2 years. This bill seeks to give an easy way for pro se parties to be able to file when there's a denial or interfering with parenting time without good cause. And it requires the court to, within 10 business days of filing the motion, to issue a summons for the parties and to make a decision within 60 days after service of such motion. And the reason behind this bill is in the unfortunate case where one parent is denying parenting time to the other child and not following a court order, there's really not much that the parents can do right now. The police will say you need to go back to court. And when you go back into court, unless the court decides that there's an immediate threat of harm, which can be a really difficult burden to prove, especially if the parties are pro se, they can't get in there and they're not seeing the child, and it's being used kind of as a weapon, and a child should never be a pawn. So I want to make sure that the parties can get in there and have their case heard. This was amended to be very explicit that it's only relative to the denial or interfering with parenting time, because there was a concern raised that people didn't want this to be used as another form of, litigation abuse, to be filing because, dad didn't return the dance clothes or something like that. And that was never the intent. I did speak with the court and they were able to meet the timeline, this timeline, as long as it was only relative to the interfering with the parenting time and not just anything that's in the parenting plan. So I really think that this is an important bill, and I hope that you guys will vote to pass it. I'm happy to take any questions. And I did want to mention that this is used also in Missouri. And when this was implemented, the fact that it listed out some remedies that could be available, which are already available to the court, it was enough incentive for parents to kind of not, without cause, just withhold the child, because they realized, there might be actual consequences because they were formally listed out. So I do think it will also help to, provide for the parents to actually follow the parenting plan. It would give a little bit of incentive, seeing, hey, I can get in trouble for not doing it. So happy to take any questions.
Thank you very much, Representative. Are there any questions from the committee? Seeing none, thank you very much.
Thank you.
The chair will call Dana Albrecht. Good afternoon, Mr. Albrecht.
Good afternoon, Madam Chair and members of the committee. I'm here to speak in strong support of this bill. When I woke up this morning, I made a pot of coffee and I said hello to my oldest son, who lives with me. But I haven't had any contact with my younger daughters in many years. They were born here in New Hampshire and have been relocated all around the country in my family law case multiple times, first to California, then to Michigan. Be that as it may, Halloween 2019, the other party told police in California that she had sole custody of my younger children. And the next day, I filed an ex parte. And you don't need to decide which one of us is right or wrong in that dispute. She's not here to tell her side. What you do need to decide is as Rep. Katab said, no one acted on that for 2.5 years. That's unacceptable. If there's a dispute like that over parenting time or withholding parenting time, who's right, who's wrong, settle it quickly, not 3 years later. As the statute is written today, and as you just heard, it only says, they have to look at it within 30 days. When I appealed that to the state Supreme Court, they interpreted the statute as written, as it exists today, that they didn't have to do anything for 2.5 years. And so, because it's just an interpretation of the statute, all of you here in this room are essentially free to override the court on that by rewriting the statute so that it does the right thing. And so I would just really urge you to pass this, because if this had been law, 5 years ago, then I think I would have had contact with my daughters who I haven't seen in years. So please pass this. Thank you.
Thank you very much, Mr. Albrecht. Are there any questions from the committee? Seeing none, thank you.
Thank you.
Okay, are there any other members of the public that would like to speak to House Bill 1006? Okay, seeing none, we'll close the public hearing. I know. Okay. Okay, are you all set, Ryan? Okay. We're going to open the public hearing on House Bill 1263 and recognize the prime sponsor, Representative Katab. Oh, excuse me. I thought it says 115.
Oh, okay. Sorry.
Yeah, sorry. The committee will be in recess for 4 minutes. I was looking at the wrong clock. That one tends to be a little fast as opposed to Apple time. Oh, it's so dreary outside. Yeah, it's like, holy, my goodness. Because when I left this morning, it was, little, but it wasn't like, and it just like looks so terrible now. Let me check my mail. Yeah, I know it is. It's okay.
Thank you, Madam Chairman and honorable members of the Judiciary Committee. Again, my name is Representative Keelan Kutab, and I'm here to introduce House Bill 1263, which is relative to the appointment of parenting coordinators. This is enabling legislation allowing the court to appoint parenting coordinators upon agreement by both parties. And I do want to stress that these would only be appointed if both parties agreed to it. And further down here, if once somebody's appointed, if either party objects to the appointment, then the court would appoint a different person. It also further states in here that a report would only be filed upon signed agreement by each party. And the reason why that was put in there is, there are sometimes parties who they simply cannot agree on something. And this gives them another tool to potentially be able to come up with an agreement. And what I was told by a few of the attorneys was, well, if it's going to be similar to a GAL where no matter what the report says it's going to go forward, then you're going to have lawyers likely involved if there are lawyers, and they're not going to want their client to go forward by themselves. They're going to want to represent them and be careful of what they're saying. And so it was really important that we put in here so that each party can, speak freely without concern of something being brought against them, and I think it is a good tool to offer because who knows the kids better than the parents, right? And sometimes when they can't decide, we don't want to judge who doesn't know what the parents' work schedules are or what the kids' schedules are, trying to decide what makes the most sense and just doing a default of, okay, they're with mom Monday, Tuesday, and dad Wednesday, Thursday, and, switch every other weekend. Well, they don't know that, dad actually works those 2 days and the other 2 days would have worked, so I think it's another tool that's available. Several other states are offering this. There had been brought a concern of DV up here, but in contacting the other states that have implemented this, they haven't had issues with it. It is requiring that, the person would be trained, have domestic violence training. And I think it's important to note, again, that both parties would have to agree in order for this tool to be used. So somebody's not going to be forced into doing this. And towards the end, a lot of times parties just can't afford to keep going on, and they would rather have some sort of an alternative to just come up with an agreement, regardless of what the situation, may be going on. So I'm happy to take any questions.
I have a question. What happens in a situation where one person really wants to do this, but the other person doesn't? Are there any sanctions against the person who does not want to do this? Is that going to be a consideration of the court?
So the court would only appoint if both parties were agreeing. So if one party said, I don't want to do it, then they wouldn't order this.
I think you misunderstood my question. I don't want to set up a situation. Goodness, I don't want to set up a situation where you have two parties that just do not get along for whatever reason. They cannot be in each other's presence without a lot of difficulty. And one says yes, the other says no. So they inform the court that they just can't agree. What I'm concerned about is it being held against or a consideration against the parent that doesn't want to participate in this. And that's what I'm concerned about. I looked through the bill, I don't see any language in there addressing that situation. I think it's easy enough to amend. I just don't want to set up a situation where you have two people that they just don't want anything to do with each other, and one wants to, but the other one doesn't. And the court will penalize the person who doesn't want to.
I mean, I guess the same could be said right now for GALs, right? If they could also penalize for that, and that doesn't say if you decline that there's no penalty for that either. I'd be okay with amending to put it in there, but I think I guess I don't see why a court would do that, because it is requiring that they both have to agree. That's set out in there, and we're only going to we can only appoint if they do agree. And I'm not aware of that happening with the GAL right now. So I wouldn't foresee that happening, but I'd be happy, if you preferred to amend it to put it in there that they can't use that against, but I guess I'm not sure that that would happen since they're not doing that with GAL right now.
Okay. It just as a comment, I've been sitting here for a few years and we've gotten a lot of complaints from parents that are in difficult situations. For some reason, there's tension between that particular parent and the guardian ad litem, and they choose not to participate because of a contentious relationship with the guardian ad litem. And while it's not readily noticeable, parents will sometimes feel that because I don't like or trust this particular guardian ad litem, that I feel that has been used against me in the proceeding. And I just don't want to take away a parent's really right to say, no, I don't want to participate in this process and have it used against them, or have it be a consideration used against them in the court.
Yeah, that's plenty fair. And I do hear you on the part about not trusting or liking that particular person that may be appointed, which is why we did amend to say that if the party objects to the appointment, that the court should appoint somebody else, because we definitely don't want to get into a situation where, a party says, I've heard terrible things about this one, I don't want to participate with this one, and they're forced to after the fact. So, but I'd absolutely support amending in there to say that shall not be used as a consideration in the proceedings. The lack of agreement on using the parenting coordinator shall not be used against either party. I'd absolutely support that.
Thank you. Are there any further questions from the committee? Okay, seeing none. Thank you, Representative.
Thank you.
The chair will call Katrina Heinrich.
Good afternoon, Madam Chair and the esteemed committee. Thank you for letting me testify. I want you to make note on what's coming around. I confused two bills when I was typing. I'm neutral on this bill.
Okay. Could you please
Yes.
introduce yourself for the record, please?
I'm Katrina Heinrich.
Okay, thank you.
So I did a kind of a deep dive into this. And some of it actually relates back to Bill 185, and there were some questions this morning from some of the senators. The one thing that I was really looking at on this is the bill really doesn't address the underlying problem of high conflict cases. So when I was looking at it, I started kind of thinking about what are the actual problems? We know there's conflicts, there's all this stuff, but what are the actual problems? And some of the questions that the senators asked this morning was really very good, actually. I think it was Senator Gannon that asked whether they're not happening in applying 50-50 parenting. And I can say from the people I've worked with in my own case, 20% of the cases, they're not applying 50-50 parenting. But you can imagine by doing simple math, the 80% that's settling out, no problem. So I would refer you to Title IV, the requirements of Title IV on that, as to why that's an issue. And Senator Abbas posed a question concerning abuse being evidence for the court to use. In that situation, I would refer you to New Hampshire Rule 2.2, which says the rules of evidence do not apply. Now, there's a caveat on it that if the judge wants to, they can. But because there's so much arbitrariness in these high conflict, Rule 2.2 has become status quo. The evidence is just arbitrarily applied in 20% of the cases. So in this respect, I would say if you pass 185, you're going to get that ratio up from 20% to 90% with no problem. And that would be my comments on that. some of the other things I was looking at is this adds another contractor role. And I handed you the second page is just kind of a breakdown of the family court organizational structure and how it operates under the judicial umbrella. It has direct business partners of the state and indirect business partners. This would be aligning another indirect business partner. And yes, there's going to be fees and stuff for the families, which is a consistent complaint, I think, across the board. One of the other things I hear a lot about is the immunity issues. So many of these private contractor roles have immunity, and while the stakeholders' position is, look, we need to attract people to these kind of jobs to work with us, we have to offer them something. I'll let you do with that what you want in your own thoughts. But optically, I see that the organizational operations adding yet another layer for parents to contend with, or I appreciated your remarks, Chairwoman, sorry, because that is a conflict situation. And I think you've picked up on that. You've made that clear. I can speak to my own case that was in over a decade post-divorce, and that is very important to understand. Post-divorce. Pulled back in 30 days for a modification. Just basically, he didn't want to pay. Do the modification, let's move on. A decade is not a modification, and I can't stress that enough. Mm-hmm. So with those kind of thoughts, I really did pull the bill and just kind of keep looking at the different pieces. The parenting coordinator role, I don't feel like it's clearly defined as to what their limitations are, what they can and can't do. It does point out that they work with existing parenting plans, but it really doesn't give them kind of the guardrails. And I also, and this is perhaps a personal note, I think I'm seeing from people I've talked to a lot of access to personal finance, family, and social information by these contractor roles. And that causes more conflict. So I have some thoughts that may need to be clarified a little better. I also think in number 6 on that page, if I recall, the state of New Hampshire says all adults are mandatory reporters. So I really think the last part that says to the same extent as a family mediator could be just omitted. And that is my overall consensus on this bill.
Okay, thank you very much for your testimony, Ms. Heinrich.
Mm-hmm.
Are there any questions from the committee? Seeing none, thank you very much. The chair will call Betty Gay.
Betty Gay from Salem. I marked that I was neutral on this because my comment is about a more basic thing than the parenting coordinators. It is that in my experience dealing with parents who have been through extensive court, that the assignment, the title of sorry, I have aphasia, high conflict, the definition of high conflict, I would really like to see that defined somewhere, because the people that I've known who've suffered greatly at the hands of the court were assigned to high conflict. And in our county, I'm not even sure that any other county has the designation of a high conflict court. There's definitely one in Rockingham County. And what the judge, or whatever term he had, he was a master, I think, at the time, he got all the cases where domestic abuse was alleged. All. Well, when you say high conflict to a person who's not inside the court, that sounds like two equals who are duking it out, fighting over money, fighting over anything. But it implies equals who are fighting. A victim of domestic abuse is not an equal. And for them to summarily be assigned to this particular case, to this particular court, was really unfair. They had no way of getting any other court, any other judge. The judge was obviously prejudiced. He would walk into court. He could tell people to leave who couldn't stay. He wouldn't allow them to stay with the litigants. He would say off the record, you'll find out more about that later, he'd say, this is a father's rights court. Okay, it's supposed to be a children's rights court, and let's see how to manage things with the parents, but not just father's rights. And his decisions were heavily weighed, and he didn't like abuse. He didn't believe in abuse. And when, I know of 3 cases that he adjudicated, and they were all a case of found abuse that had been through courts and already decided by 3 judges. And he had no problem calling them back into court and making them follow new rules to favor the abuser, including paying for his counseling. The list was long, but that was just one thing that was just outrageous. So I would really like to see the definition of high conflict defined.
Okay, thank you very much for your testimony. Ms. Gay, are there any questions from the committee?
Thank you.
Seeing none, thank you. The chair will call Erin, is it Jazina?
Good afternoon, Madam Chair and members of the committee. My name is Erin Justina. I direct the Domestic Violence Advocacy Project at New Hampshire Legal Assistance. We represent low-income victims and survivors of domestic violence, sexual assault, and stalking in their domestic violence protective order cases, as well as high lethality family law cases, so divorce and parenting cases. So the cases where we are involved, there is a high likelihood that our client will be seriously harmed or even possibly killed by their intimate partner. I am here today to testify in opposition of House Bill 1263. I'll keep my testimony brief. It's probably been a long day, but I really just wanted to make 3 points.
I'm sorry, I don't know why my phone's going off.
The first point would be line 4 on page 1, section 1. The court may appoint a parenting coordinator in high conflict cases upon agreement by both parties. I think the very nature of high conflict cases suggests that this bill in a way would be essentially moot because high conflict cases, very unlikely that there's going to be any sort of agreement. So then you're really looking at the parties not agreeing. And the second point in relation to that is if the parties aren't agreeing and if this bill, if it becomes law, were to require agreement by both parties, I could see in a domestic violence situation where there could be coercion and control to get the other party to agree. And why is there that coercion and control? To what end? What is the end goal by the abuser? So I could see this as another piece, another tool really in the abuser's toolbox to further the abuse through litigation. And then so in regards to the domestic violence, there isn't an exception for domestic violence. Mediation, for example, there's an exception. The parties should not have to participate in mediation if there is a protective order, for example, or a criminal bail protective order. This bill does not provide for any of those exceptions where there's domestic violence or there's child abuse. I would also, so my last point would be in regards to how this would affect the mediation fund, which is available for indigent parties. Indigent parties in a parenting case that would require a parenting coordinator, unlike the GAL fund, which does not, we don't have a GAL fund anymore for indigent parties. So unlike the GAL issue, this would allow, if someone wanted a parenting coordinator, this would allow indigent parties to tap into the mediation fund. The concern there is that it would really draw down on those resources
There is no determined period of time in this bill set forth for how long parenting coordinators would be involved in the case. Is it just until there's a final order? Is it until, the kids turn 18 and we're dealing with 2-year-olds and 3-year-olds in a case? And is that how long is the person involved in the case? How long is payment through the fund going to happen? And what effect will that have on parties being able to access the mediation fund? So those are the points that I would raise in our opposition to this bill. Thank you.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you. The chair will call Dana Albrecht.
Good afternoon, Madam Chair and members of the committee. Dana Albrecht, Nashua, New Hampshire. I agree with the sponsor's characterization of this bill as a useful tool. I think it is a potentially useful tool. With that said, you already heard this morning the real solution. This is about high conflict cases. What if we just got rid of high conflict cases by passing HB 185? Maybe not 100%, but it would cut it way down. And what you heard this morning on HB 185 is the solution to keep the Titanic afloat and everybody happy. And what you're hearing with, again, a potentially useful tool is how to make the deck chairs look pretty. And there's nothing wrong with that when everybody's happy on the ship. And, so with that said, I'd just like you to consider that this is a nice little tool potentially. But the real solution was this morning. And there's just one very final technical comment. Page 2, lines 11 and 12, I see the words shall be immune. Deciding whether that should read as is or should be afforded qualified immunity is probably above my pay grade, but I'm sure you guys might wish to discuss that.
Thank you very much for your testimony, Mr. Albrecht. Are there any questions from the committee? Seeing none, thank you very much.
Thank you.
Okay, seeing that everyone who has signed up and wish to speak has spoken, are there any other members of the public that want to speak to House Bill 1263? Okay, seeing none, we'll close the public hearing. The committee will be in recess for 6 minutes. The committee will come out of recess and we will open the public hearing on House Bill 1266 and call the prime sponsor, Representative Katam.
Thank you, Madam Chairman and honorable members of the Judiciary. Again, my name is Representative Caitlin Kutab, and I'm here to introduce this bill relative to allowing parties to record proceedings which are open to the public in the family division of the circuit court. Currently, by court rule, they can already ask the court the day in advance to record. Sometimes you have pro se parties that weren't aware of the process to ask in advance, and at the time of their pro se, they want to record what's going on, and this would allow them to do that. It's very clear that it can only be if the proceeding is open to the public, so this doesn't apply to confidential cases. The recording device can't interfere with the proceeding, and it's only limited to the proceeding that the party is participating in, and that the electronic recording or transmission of private communications, including bench sidebar conferences between counsel or conferences between counsel and client, are prohibited. So I think the party should be allowed to record their testimony. We've heard some testimony where there were times where the court recording device had malfunctioned or failed to record for some reason. The party should be able to do it. And I do want to note that in terms of concern for privacy, again, these are hearings that are open to the public. And if the court system's recording doesn't malfunction, anybody, you or I, can go and get a copy of any court proceeding that's already happening, a recording of it. So there's no reason why the party shouldn't be able to just record it, because the recordings are open to the public. So this is really just letting them do it themselves. And I think that it's a good bill. So happy to take any questions.
Thank you very much for your testimony, Representative. Are there any questions from the senators? No, seeing none. Thank you. Oh, wait a second. Senator Abbott has a question.
Thank you, Madam Chair. This recording that the party makes, is that something that would be appropriate to then be potentially transcribed into a transcript? Or would you have to still use the audio recording from the court?
No, you'd still use the audio recording from the court. I think that especially like the Supreme Court, like specifically states that only a certain company can even do the transcriptions anyway. It's the same company that they've used, I think it's in Arizona, for like a decade.
Okay.
Thank
you
you.
very much, Representative. The chair will call Betty Gay.
Betty Gay from Salem. This is a very, very important bill that we've tried to get passed before, but due to misunderstandings, it just got discussed. One reason that it is just critical to allow people to make their own recordings is that we have discovered many times serious discrepancies in the official recording. We found out, as people who will testify after me, who unfortunately I should have been speaking after them, but they weren't there to sign up when I did. We've actually seen in writing the transcription company saying that they feel obligated to, quote, clean up the recordings. So if they think something untoward is said by the judge, they remove it. So besides the fact that, there can be misunderstandings in a recording, that can happen. It's really good to have a backup. You've already mentioned some other facts have been, repercussions have been just mentioned, that right now, the only way to get a transcript is to buy the official recording, court recording, and pay quite a high fee to have the transcript that's made. Nowadays, I'm sure we could use some other carefully written bills so that we can, now that we have software that can convert the spoken word to the written word, surely we can make this a little more affordable, but that's the whole matter of law that this bill cannot touch. So I'm just saying this bill is really, really important, and I think we do need to inform the transcription service that they do not have the right to quote, clean up language that they hear that they're supposed to be transcribing, especially when it's something that's culpable behavior. And it would also be nice because the personal recording could cover all the blank times, whereas the judge or whoever is recording can start and stop. And so they can accidentally or deliberately not record everything. So this just gives the person, the litigant, a chance to have a totally clean copy. And if they have a problem with an official transcript, this will give them something that they can say, but I know this is not correct. And right now they don't have any way of showing that an official transcript is not exactly 100% right.
Okay, thank you very much for your testimony, Ms. Gay. Are there any questions from the committee?
Thank you.
Seeing none, thank you. The chair will call Aaron Cregan, excuse me.
Good afternoon, members of the committee. My name is Erin Cregan. I'm the general counsel for the New Hampshire Judicial Branch. The court agrees that recording should be liberally available to the public. The court ruled so in Ray WMUR almost 20 years ago, that it is in our pre-state constitutional and federal constitutional common law that there is a right of access to the courts. It has been the policy of the court system to have a relatively open recording policy in that time, which is given on our website. If a person is in need of frequent recording, which is something that members of the press, but also private individuals often want to do, they can register. They understand the rules. They can't interrupt. They can't have an obstructive camera placement. And then they simply check in with the clerk and let them know that they're going to be recording, at which point, if it's, for example, a high-profile case, pooling arrangements may need to be made. There may not be enough space in the courtroom for all the different media that wants to be there. But for most private cases and private persons who want to record, it's usually a case of interest to them, and they can do that as well. You don't have to be a member of the media to record in the court system. You fill out a one-page form, which is a day pass, which can be filled out at any time, including while the proceeding is ongoing, and is usually presented to the clerk. It can also be presented at the door to the courtroom. That simply lets know who it is, what they want to record, and that they understand the recording rules. Can't be obtrusive, for example. So we have many members of the public that do record without incident. There are a small number who are committed to disruption, and that is a basis for someone to be disallowed from recording. But there's no policy of the courts to make it difficult for private citizens to record. In fact, we very much hope that people will be encouraged to read those rules and to follow them and to record as much as they would like to in compliance with the court's rules. I appreciate that in her drafting of this bill, I had an opportunity to coordinate with Representative Kutab, who is always extremely thorough and speaks to many people, and I am one of the people that she spoke to in formulating it. And there are, many aspects of this bill that are an improvement on, I think, past similar bills that maybe had some problematic elements that she's considered issues like confidentiality, sidebar conversations, that a person can't be disruptive. What I would say is a question for me as the attorney for the court system is any part of this bill intended to displace the court's existing recording policy? As I read it, it does not. And I think my current advice to the court system would be that our existing recording policy would continue unmodified by this bill. If that is the legislature's intention, it would be helpful to perhaps add at the end of the bill that nothing in this is intended to displace the court's existing rules or policies, so that there is no confusion for members of the public or for any person reading the statute that there is a conflict that has been set up. But I'm happy to answer any questions you might have on the court's recording policies.
Thank you. Senator Abbas has a question, and so does Senator Chandler.
Thank you, Madam Chair. I'm not sure if the court policy addresses this, but this says they shall have the right to make the audio or visual recording. Any concerns about cases where the witness is a child and potentially child also victim of a crime?
So the holding of in re WMUR is that that right exists, but it is not unqualified. And I wouldn't necessarily take this language of the bill that it's intended to, it's recognizing a right which exists, but I wouldn't have understood it to be overcoming that there are other rights that have to be balanced in the court system. So it's not the case now that folks can record in a closed hearing, and I don't understand it to be the policy intention of this bill to change that, but I should defer to the prime sponsor on that question.
Follow up?
Thank you, Madam Chair. There's some cases, and it may be open to the public still, but you do have a child witness or someone, there's an intimidation factor, which may not be the intent of the person making the recording, but nonetheless has that effect. I don't know if there's any policy that exists that would address that issue, and if not, are there any concerns about perhaps, spelling it out in the law like this?
One of the things I would say is an advantage of the recording policy, which has become longer over the years, is that it's informed by experience. And we do have instances where parties have objected to recording for one reason or another. In this, the use of the sheet and the notification where the court says, all right, someone's going to be recording, is an opportunity for a party to raise that issue. If there's not a notification of some kind and the recording is potentially covert or it's not clear, then there's not really an opportunity for a party that has some reason to object. Now, that objection would have to overcome that common law presumption that folks could record, but there could theoretically be a case in which there is good reason for the court to not allow recording.
Senator Chandler?
Thank you. In the current process, and a form is filled out, is there a granting of permission, or is the form simply notification?
For a registered person, a person who is frequently recording, is simply a notification. For the one-day pass, which most people only record once, they're recording their own case or a case of a friend or family member. It is approved, but it is almost always approved.
Okay. Thank you.
Are there any further questions? I just have a question. Does this bill open it up more, or does it close it? Because it's a little confusing. It says here on line 9C, the recording is limited to the proceeding in which the party is participating. Is that what exists now?
At this time, any person can record in an open proceeding. There's not a requirement that you have a personal nexus to the case. But I don't necessarily read that the bill eliminates access, but it only covers situations in which are in the family court and which a person is a litigant. Recordings allowed in all of the courts by any person. So it is addressing a broader number of circumstances, but I don't read the language to explicitly ban other forms of recording simply because it does not also enshrine them. But I take your point, it could be confusing that it's limited to a more narrow number of circumstances than the current policy covers.
Okay, thank you. Are there any further questions? Seeing none, thank you, Ms. Cregan. Okay, the chair is going to call Dana Albrecht. Good afternoon again.
Good afternoon again, Madam Chair and members of the committee. Again, Dana Albrecht, Nashua, New Hampshire. To echo a couple previous sentiments, but then apply them to this bill. I believe this is another sort of useful toolbox bill, wherein the dreadful underlying problem is deliberate falsification of the court record, and particularly cases of appeal that is utterly unacceptable. We have at least one former judge in the state who was convicted of falsification of court records. What you heard from Representative Betty Gay earlier about proven judicial misconduct being deliberately omitted from a transcript, with emails from eScriber saying, of course we're not going to transcribe that, actually happened in my case. I didn't have time to go to Staples and print this out, but you can just download it off the internet. judgeking.com or Google Judge King deposition. But for hard evidence, I refer you to the e-scriber's email about my transcript written November 12th, 2020, about a hearing November 6th, 2020, so right after the hearing. I refer you to the email written by Judge David King the following day, November 13th, 2020, where he's aware of the problem. I refer you to the JCC response to Judge King, February 16th, 2021, and I refer you to Judge King's deposition, August 26th, 2022, where he discusses the issues with the transcript in my case. So again, a very useful tool that I think helps people keep people honest when we might not agree that what we're getting from the court system is accurate, or where e-scribers is saying they're going to deliberately tamper with that. You know, checks and balance doesn't solve everything, but helps. I would also just like to address briefly General Cregan's comment on the existing system for recording. I can recall on just 2 occasions where I actually wished to record someone else's media. There's a criminal case up in Conway where a large number of people showed up because they felt the defendant was not receiving a fair hearing. Be that as it may, you know, that's exactly why we want open courtrooms, to shed light in situations. I do know that Miss Lori Ortolano, you know, who won a First Amendment award from the union leader, put in a one-day slip, and the judge denied that. And I did as well. So that system doesn't always work either. With that said, I am very respectful to her comments, where we want to make sure that, you know, whatever the final version of this is, that we're not limiting what people can already do, but rather expanding it with a tool to keep everybody honest.
Okay, thank you very much, Mr. Albrecht. Are there any questions? Mr. Albrecht, I'm going to ask you the same question that I asked Ms. Cregan. On page, the first page, line 9, subsection C, the recording is limited to the proceeding in which the party is participating. You described a situation where there was an issue with a case up north and a lot of people went up. The way that this looks, it's basically saying, unless you're a party, you're not going to be allowed to videotape. Instead of opening it up, it looks like it's closing it up more than anything else. And we've heard a lot, even today, people talking about a particular case that they might have had in front of the court with a particular judge or a particular lawyer. And you might want to gather enough evidence that you could perhaps make a complaint at the court about a particular judge. So you're going to want to videotape them in a variety of different cases. But if this was to pass, it looks like unless you are an active participant in a case, you're not going to be allowed to audio tape. I just, maybe I'm just misreading this, or I'm just thinking what your thoughts are.
Yeah, if I may, to address that, in the first instance, if we accomplish everything that we're intending to accomplish here with some language cleanup and exec, just to make things clearer, you know, nothing wrong with that. That's a good thing. Is to address your specific comments. As I read the bill right now, in line 5, where we're talking about parties, it says shall have the right. And I think right is a key word there. There's a right if you're a party. And the existing recording mechanism for non-parties, at the end of the day, is at the judge's discretion. And then in section 2, lines, 13, 14, it says, nothing in this section shall prohibit a party or a non-party who is otherwise authorized by law or court order. So I think number 2 sort of covers the existing system, and number 1 is adding an existing right for parties. With that said, if someone wants to mark this up to be much clearer, by all means.
Right, thank you very much. Are there any further questions for Mr. Armour? Seeing none, thank you. Chair will call Katrina Heinrich.
Hello, I am Katrina Heinrich, and gosh, everybody's been wonderful on getting some facts out on this bill. For me, I support the bill because it sounds like it's going to totally minimize the occurrence of discrepancies, which has been a huge complaint in the family court and children and family law. While I did highlight some bullet points, I'm not going to repeat these. You've already heard some of this. I have some notable quotes from January 2023 and January 2022 that are conflicting that you may want to apprise yourself of. You know, and I was thinking about the children factor in family court. One of the things that keeps coming up consistently is people have said, well, what about these in-camera interviews the judges can do with the kids? It is rarely, and I mean rarely, that I've heard it's granted. I know of cases that have asked for it for several years in a row, and they still cannot get that. But these children are well over the age of 12, 13, 14, 15, 16. So just something as a consideration when you're thinking about like a child being there. They're not typically in the room, and I know there's talk about letting them in the room. So something to consider. You guys have a bigger picture to look at. That takes care of the in-camera, and honestly, I think everybody else did a wonderful, wonderful job, and I just think that this helps close the gap of discrepancies and helps assure constitutional rights.
Okay, thank you very much for your testimony, Ms. Heinrich. Are there any questions from the committee? Seeing none, thank you. The chair will call Marissa Chase.
Good afternoon, Madam Chair, members of the committee. Thank you for allowing me the opportunity to testify. For the record, my name is Marissa Chase. I work for the New Hampshire Association for Justice, which is a statewide professional association of trial attorneys. We are here in opposition to this bill. We've opposed similar iterations in the past. I really respect and appreciate the prime sponsor's effort to incorporate some of the concerns that we had shared with her in the drafting of this bill. Specifically that on line 10D, electronic recordings or transmission of private communication of others, including bench and sidebar conferences between counsel and client are prohibited. The problem is I don't know what the enforcement mechanism would be of that. Judges and counsel at tables in a courtroom have a button like this where they can mute from conversations. Knowing that technology is ever advancing and quite sophisticated, would there be a limit on what kind of recording equipment? How are we going to make sure that conversations between attorneys and their clients are going to remain privileged, that bench conferences with the judge are going to not somehow make its way into the record? That opens up a wiretap concern. In New Hampshire, we are a two-party consent state. You cannot be recorded unless you have unless you're in a public place. If you have a reasonable expectation of privacy, you must consent to being recorded. So what if this were to pass as is and a conversation between an attorney and their client was picked up on the recording and they had an expectation of privacy in that conversation? Does that then open up the person who made the recording to some sort of recourse, reprimand, what have you? I also want to point out I was sitting in the audience, I was looking at the
courts.nh.gov, the rules of the circuit court, Rule 78, photographing, recording, and broadcasting. Starts off by saying, except as otherwise provided by this rule or by other provisions of law, any person, whether or not a member of an established media organization, shall be permitted to photograph. No person shall photograph, record, broadcast any court proceeding without providing advance notice to the presiding justice that he or she intends to do so. In addition to giving parties an interest and opportunity to object, the purpose of the notice requirement is to allow the presiding justice to ensure that the photographing, recording, or broadcasting will not be disruptive to the proceedings and will not be conducted in such a manner using equipment to violate the provisions of this rule. And it goes on, and I'm happy to send this link to Matthew so the committee will have it. But it's quite extensive in terms of governing where the equipment is, who has access to it, and making sure that there is notice. It all really comes down to judicial discretion, which I do believe is really important. I do believe that the presiding judge, should have the authority to determine, the best circumstances on a case-specific basis. Senator Carson, you had mentioned before line 9, section C, the recording limited to the proceeding in which the party is participating. I had a different read on that line than you did, and our concern with that is, what if a recording is being used for appeal? Is it limited to, can you use your own recording if you're going to file an appeal? Or is this recording can only be used for this one proceeding that you're in recording? Another concern we have about that is chain of custody. If a party is going to make a recording of the proceeding in which they're participating, what's going to stop them from altering that recording potentially? If all parties are allowed to make their own recording and the court has a recording, if an appeal is filed, will everybody have to submit their recordings for the record of the appeal? For use and disclosure for both sides. I just think that there are not enough safeguards and parameters, and this really has the potential for abuse. I'm happy to try to answer any questions.
Thank you very much for your testimony. Are there any questions from the committee? Senator Abbott has a question.
Thank you, Madam Chair. I'm not sure you'll be able to answer this, but if a organization, ACLU, whoever, were to file like an amicus brief, would they be a party for the sake of recording? I'm just wondering, or do you have to be a named party? I presume that's a named party, but sometimes on appeals, people kind of jump in.
I don't know the answer to that, Senator. I'm sorry. I'll think about it and try to get back to you.
Do you have a follow-up, Senator?
Thank you.
Okay. Are there any further questions? Seeing none, thank you very much.
Thank you.
Okay, are there any other members of the public that would like to speak to House Bill 1266? Okay, seeing none, we'll close the public hearing. Come and sit down. I know you've been running in and out of here all day because, and I appreciate that. You're very conscientious. You want to be here to testify on your own.
Not even give him a hard time for his attendance record because he missed a few votes.
Well, no, I don't think I missed any votes, actually. Maybe one division vote, I don't know. But I had to be here for the members of the Senate. I very much so respect you giving your time to this bill today.
Wait, before you get started, I have to open it up.
Oh, please, yeah, sorry.
Yeah, we have
Formalities.
You all set, Ryan? We're going to go ahead and open the House Bill, open the public hearing on House Bill 1169. Recognize the prime sponsor, Representative Jonah Orion Wheeler.
Thank you very much, Madam Chair. For the record, I'm Jonah Orion Wheeler from Peterborough, representing the towns of Peterborough and Sharon. I am here in support of HB 1169. I'm the prime sponsor of this bill, shepherded it through the House. It passed the Judiciary Committee 17-2 and the House on the consent calendar in its current form. Representative Lynn, Chief Justice of the former Chief Justice of the Court, hard to tell sometimes, I guess, but looked very diligently at this bill. I know both sides looked very diligently at it. I know that there's some things that might need to be worked out. I totally understand that, Madam Chair. I think that there is consensus around the principle of the bill. And so I'll just sort of reiterate, I think it's non-discrimination for hair, I think, is important. And that's why I proposed this bill. I went through it myself, as I told the committee here earlier this year. And however we can shepherd this bill through, I'm happy to do that. So I thank you for your time, Madam Chair, and
We're here for you
happy to
today,
take any
Mr.
questions.
Representative Wheeler, so. Does anyone have any questions for Representative Wheeler? Senator Whitley has a question.
Thank you, Madam Chair, and thank you for your patience today. Can you tell us the major differences between your bill and the bill that has already passed the Senate?
Absolutely. My bill has the, I think they would be described as causes of action. If they have an issue with discrimination based on their hair, then they could either go to the court or the Department of Labor. In Senator Prentice's bill, I believe that includes the Human Rights Commission. I did not amend my bill to include the Human Rights Commission because, as far as I understand, and this is from people who are at the House Judiciary Committee, and this is with all respect to the Human Rights Commission, I know that they do hard work, and a lot of our state agencies are overburdened, but as I understand it, there is a years-long backlog for requests before the HRC. It's not the case with DOL or the court, and so I figured if people actually want to have their actions heard, that Department of Labor and the courts would be the appropriate place for that. So that's, again, said with all respect to the Human Rights Commission. I hope they can get the resources they need to fix that backlog, but I just think the appropriate place for the causes of action that we're talking about here in 1169 are the Department of Labor. And I actually have to run, Madam Chairman, if it's okay with you. I can be back after this, but they are calling a vote right now.
Great,
If that's
no,
possible.
go right ahead, Representative, you better go.
Come on, it depends what.
No, you better go, I understand that.
Oh, no, and yes, me too.
Okay.
He's fast.
Are there any other members of the public who would like to speak to 1169?
I was gonna ask a question, but he had to go.
Okay, seeing none, I'll close the public hearing. Okay, so he doesn't have to keep running back and forth.
Poor thing, yeah.
Oh, gosh. On the last one, folks. Did I have one person? I wonder if the state rep is here. Okay, this is at 2 and we're at 2:30. Okay, I'm going to go ahead and open the public hearing on House Bill 1639. Is Representative Kassadin here? Please do the honors. Thank you very much.
Good afternoon, Senator Darrell Abbas. I represent District 22. I'm here to introduce HB 1639. At the moment, I am neutral on the bill.
Thank you very much, Senator. Hey, the chair will call Rebecca Fredette. Good afternoon, Ms. Fredette.
Good afternoon. Thank you for having me. My name is Rebecca Fredette. I'm the State Director for Special Education over at the Department of Education, and we worked with Representative Cascadin for this bill. We're asking for two things. One of them is that currently there is no record retention policy for our special education information system. We just have to hold on to things forever. And so we're asking that we follow the same retention schedule as the school districts do, which would be the age of 26, or if a parent asks, up to the age of 30. So that then we would, we would get rid of the records after that time period on the same schedule that a school district does.
I'm sorry, I heard you say 26 and 30. That you're just talking about maintaining the records.
Yep.
You're not talking about providing services.
No, it's
Okay.
just maintaining records until the age of 26, and then a parent can request that they be retained until the age of 30.
I apologize.
No, that's
I'm kind
okay.
of shocked because my daughter has multiple disabilities and receives special education, and we were told 21, that's it. And I go, when did the law change?
No, just records.
Just records, okay,
Yeah.
great. Thank you. I'm sorry for interrupting.
No, that's okay. The second part of the bill is just cleaning up some of the language that is in 186C19A, and we're asking for more generic language than specifically citing the Youth Services Center or the Detention Center, and changing that language to in-state facilities for detained or adjudicated youth and county correctional facilities. This will provide for when we don't currently have a detention center, there is a Youth Services Center, but as things change and names change, this is just making it a generic term so that we don't have to come back to you in a couple of years and change it again. We have talked with our partners at DHHS, and they helped with the language on this and felt that this was an appropriate change as well.
Okay, thank you very much. Are there any questions from the committee? Seeing none, thank you. Okay, are there any members of the public that would like to speak to House Bill 1639? Okay, seeing none, we're going to close the public hearing. Seeing that we have heard all the bills that we had scheduled for the day, I'd like to thank the committee members for once again hanging in there for an exceptionally long day. Mr. Shelzy this morning, and Brian this afternoon, our intern Adam, who's done a great job, and the members of the public that came in here today to testify. So thank you all very much. Everyone have a great day.